Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati hihihanggang police, very much love you.
That's literally not true.
I didn't ask you to interrupt me.
Already. Send someone with more experience. Hello, can you hear me now? Test. Is it working now? This is already used this mic and I had it adjusted a little bit, but here we are. We're back. Wow, what a lunch! I'll be coming here on the Daybell hearing. I've got the Daybell hearing going in the other window right here. That's currently they're in a breakout session. Got that recording monitoring on this side. We're waiting for them to come back. Chad Daybell's lawyer wants out. He says, I don't want to be here anymore. Please, Judge, can I go? And the judge starts questioning him and saying, why, what's the problem? He says, well, it's not that I don't want to get paid. And he says, well, it looks like to hear like you do. That is the problem. You want to get paid and you're not getting paid. They've gotten to closed session for a little while. So we'll see how this ends. Let me speed this up. Hang on just 1 second. They've been in closed session for about 22 minutes now. Keep that going that way. Monitoring there. Okay. All right. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Thank you very much for coming back today. We are about to begin with
Somebody just sent me a video of roaches fighting. I don't know who won.
Yes. We're about to begin with the Treehouse murder trial, which is
Not a camel.
which is picking up where we left off. Let me put everything back where it goes. Oh my goodness. We got one hearing going on that the lawyer wants out, another one where the lawyer wants back in, says Becca. Yes, it is bizarre. You've got Delphi and
Don't
Daybell.
miss the forest for the trees.
Crazy. Daybell's a crazy one. It really is. His lawyer is making an argument that seems to be exactly opposite what he put in his motion. And then the judge says, well, let me ask you some insightful questions. Judge Boyce, I believe his name is, says, are you prepared with a mitigation specialist should there be a conviction in this death penalty case? And Daybell's lawyer's like, Judge, I think, can we go in closed session? I'm not comfortable saying this in public. And he's like, yeah, let's do that. They're in closed session right now, and we're going to see just how prepared he is, and the judge might have some harsh words to say to this attorney. Let's see. Katia says, I got my husband into the trial because of you, all right? Thank you, Katia and husband. Good to have you here. Hello, Princess Buttercup. Good to have you here as well. Hopefully Rebecca's doing well. Uncivil Law covered the Delphi hearing. I saw that over lunch as well. That was great. Brandy's case picking up. We rated Brandy at the beginning of lunch as well. Lots and lots of things to watch. I tell you, Super Bowl continues. It's not just a one-day thing here in true crime. This is the year of the trials. I think that's it. If we can get Corey Richins, Sarah Boone, and Brian Koberger all to go to trial the same year, what more could you ask for? Honestly, this would be crazy. What's for lunch? I had a lasagna casserole, which is like a bow tie pasta with unhealthy amounts of cheese.
I'm not a cat.
And I heated that up, and then I added additional cheese. I added Parmesan cheese onto the top of it because the other cheeses were not enough. So that's what I had with sausage, not hamburger. It was amazing. There's more left in the fridge, Becca, if you want to grab yourself a plate. I just heated the small dish of leftovers. My kids are not a big fan of that. So, buffer, chat not on screen. That's because I pushed the button over here, which is not working because I'm recording on that laptop. Chat is now on screen. Thank you, Sharon McDonald, which is a good time now to celebrate Krista, who was first in chat today. Krista with the sharp S's. Thank you very much for being first in chat. Krista, you have done this many times before. Yes, there's enough for everybody. Help yourself. It's cold right now, so you have to put it in the microwave and only one plate at a time. And make sure you cover your dish so it doesn't like splatter on the microwave and everyone has, if it does, you have to clean the microwave afterwards. Anyway, great lunch. Nap time coming soon. Let's see. Barbara says, just received my Stevens Cocoa. Wow, so good. My husband thanks you. Barbara, I would not lead you astray on something so important as hot chocolate. That is the best I've ever had. Kimar says, I'm making stuff and all I keep hearing is RA say, cheese. Yes, cheese. Kim, we go through a lot of milk in this family. And by a lot of milk, I'm saying
break for lunch, Judge.
we go through 8 gallons of milk a week. And we could go through 10. We only go through 8 because that's all we can fit in the fridge. We can't fit any more gallons of milk than 8 in the fridge. And we go through 8 gallons a week. Cheese, we buy like 15 pounds of cheese every 2 weeks. Like cheese is our go-to. It is, and we buy many different varieties. Sometimes we buy like, ricotta and cottage and cheddar and Parmesan and Monterey Jack and Colby Jack and it's always mild cheddar. I will say we're not a sharp cheddar family. No fish in the microwave too. That rule applies to all offices. Karen Reed trial, yes, we have that going on as well. There is so much happening. Let me jump over to Treehouse because that's where we're going to pick up this trial. Let's see. I think we are set there. We've got audio in case it goes live. We're good. We'll turn this one off on that. Do I have a camera 7?
Somebody just sent me a video of roaches fighting.
Mm-hmm.
I don't know who won.
Honey maple bourbon pickles are awesome with cheese. I have not done that combination yet. I keep them separate. As a matter of fact, I would say that I prefer my my spicy maple bourbon. I don't know why you said honey, and now I'm saying honey. But my spicy maple bourbon pickles, I prefer them by themselves. They are the perfect snack on their own. Cold, straight out of the fridge, fork, single serving, 1 jar per person. That's how we roll. I thought 6 liters of milk was a lot. No, Marissa. We often joke that we need a cow, but in reality, I think we would need 2. All right, let's see. I'm most interested in Karen Reed trial. Nicole, that one is going to be crazy. That case also has elements that are very similar to what we're seeing in the Treehouse trial, where we have questions about the investigation, questions about some of the evidence. It's just something's not adding up there either. All right, I like my S's and my cheese sharp, says Adam. Adam's a big into sharp cheese and sharp S's. Where can one find these pickles, says Bravo Chick? Only at Walmart. Well, I guess you can also find them at, what's that other store that's right next to me? Food Lion. Food Lion has them as well, but they're spicy maple bourbon pickles, top shelf pickles, I will say. Not that they're top shelf so the kids can't eat them because the alcohol is all cooked off. There's no alcohol in there. But these are great pickles. Anyway, they're like $3.84. They were on sale for a while. You should have stocked up. And I think the sale is over now. But they're delicious. Not at Sam's Club, unfortunately, Bravo Check. I would buy them by the barrel if Sam's would sell them, but it's only like the 24-ounce jar. Amazon? Does Amazon have them? I tell you, I know there is a company out there who's making them for Food Lion and Amazon. Or not Amazon, Food Lion and Walmart. There's some little company out there who's like, yeah, we've been making Grandma's recipe for spicy maple bourbon pickles since we were, knee-high to a grasshopper, and now we're going to continue doing that. I need to know what that company is. So if we could do some digging on that, I would like to support the people who came up with this recipe. Market Pantry version at Food Lion, yes, and they cost about 10 cents more a jar. That exact same jar, same pickles. There's no difference other than the label. Let's see. We're keeping an eye on this. Kurt Uncivil Law is watching this as well and keeping everyone up to date. Let's see. Got a text here. Let's see. Tammy Dunlap. Yes. Yes on both counts. Thanks for your text. Appreciate that, Tammy. Let's see. Never heard of Good Lion. Food Lion. Food Lion. That's where we're at. Court starts in 4 minutes. We're hoping that the defendant is there, that Mr. Tucker is going to be present. He has been late a couple times coming up to this. He's had reasons sometimes, and sometimes I think it was the judge's fault because both sides were late that day. You got to see what's the common denominator there, and they both thought the judge said something else. But Kurt's not doing this afternoon. I tell you, there's a lot. There's a lot going on. I'm still watching the court out of Idaho as well for Daybell to see if they let John off his case. All right, little bit of motion in the courtroom. We're going to keep an eye on that. Let's see. I learned a lot about delicious things since I'm here. Iris, this is the place to share all your delicious recipes. Food is always an appropriate topic on this channel. We all eat, and we all know it. So sharing the best of what we eat with each other is appropriate. Food Lion is such a South thing. Let's see, watch the hearing. They haven't made a decision yet. Susie Mack says, yay, excited to make it here first time. Pacific Standard Time, and usually then playing catch up. If you're on the other side of the country, this particular case is not your friend because it's in Florida on Eastern Time, and I realize those few hours of difference make a big difference when you're talking about catching up live. It makes a very early morning for you guys sometimes. Luckily today the court has not started till 1 p.m. because the judge had some other docket material to address, cases to address. All right. Is Food Lion part of the Kroger family? It's not. It's not like Smith's Kroger. I think it's a completely separate chain from my understanding. Judge Cranky Pants mood. I'm going to go with Eeyore again today. Johnny Desk, that's my guess. Crackpot apple pulled pork today. Oh, crockpot. Crackpot would probably be better as well. I don't know why I thought red crack when you said crock, but crockpot. Crockpot is a slow cooker, right? Slow cooker apple pulled pork. Anytime you're doing pulled pork, slow is key. Slow is key. The Delphi judge is getting smacked down. It says no mandate's not a Fed. We'll have to look at that when that, looking back on that. My phone autocorrects to crackpot. It's like, I know what you're talking about. All right, we're getting ready to start. I appreciate all those who click the like button on the feed. It may be a small thing for you. It's actually a big thing for the channel. It really does help us. It helps other people find us. I can't stress this enough. Having a year of YouTube under my belt and being able to look back on the metrics and see what happens. Those videos where we received a lot of likes. A lot more people are able to find us, and if you like what we're doing here and you think more people like you should be here, please click the like button. It helps a ton, and it's free. It's the freest thing you can do. So thank you for those who are doing that. All right, we have. Let's see, let me close that. Let's see. It's yes, Sam's Choice is the brand. Sam's Choice Spicy Maple Bourbon Pickles. Now, even though it says Sam's, you'd think it would be at Sam's Club. Not so. Not so. All right. Krista, you're at the helm. You've won the internet. Congratulations, my friend. You know what to do. You've won many times before. Repeat offender, habitual offender, huge rap sheet. But also, we trust the internet in your capable hands. Let's see, have you checked the Maya papers? I checked this morning, and I also finally subscribed. For some reason, I never subscribed to this trial. I've always manually gone out and checked, probably because I check it more often than I check my email. But let's see, I have not seen if the judge has responded. Ooh, hang on. Is there some goodness out there we need to see? see what else is on there. Oh, we've got all sorts of exhibities. Exhibities up the wazoo. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 different exhibits have been filed in the Maya case. Let's see if they're all redacted. Mine just looks black. Let's jump around, find another one. I can't even see who filed them. Like the cover sheet is black. Maybe my computer's just not cooperating. This one's 10 pages of blackness. Oop, judge is here. Everyone, sit down. Let's be quiet.
Okay, this is State versus Franklin Tucker, case 17 CF 841. I see prosecutors are here, but I don't see Mr. Tucker.
Oh no. 4 times.
Some word from the front door. Has the state received any?
No, Judge. We have not received anything, Your Honor, based on multiple violations of your request to be a court on time. We're at the point where we're ready to ask for capious.
They're asking for a capious.
I'm almost ready to
capious warrant.
Our witness is here.
You can't begin without him. I'm sorry. It doesn't help. You're still getting dressed for court.
In other words, if we...
Capious warrant is a warrant issued in connection with the failure to appear before the court in a criminal case. A defendant who fails to appear. In a criminal proceeding, for example, could be expect a capious warrant to be issued for his or her arrest. Since a capious warrant is a compelling writ, a judge or magistrate must be prudent and ensure that he or she has compelling evidence to issue such an order. This is the 4th time.
Well, I'll give it till 1:15. And if
Judge granting 11 more minutes.
Beforehand, then let me know. If not, then I'll go from there.
Okay, so we're waiting for that to happen. In the meantime, it looks like let's just listen in to Idaho for just a minute. Just audio only for a second. This might be a little confusing, but let's see if we can hear any audio from Idaho. And I'm not hearing it. Oh, that's because I have it on the wrong feed. Let's see. Judge voice just barely came back in. Let me pull this up. We're going to bring this one over here. Take a peek at what he's doing. And let's turn that one off. Turn this one on.
Shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present argument in support of the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion.
We have audio from the other court live too.
Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional.
This is
courts
Chad
that have
Daybell
reviewed that and provided
that we just jumped in while we're waiting for Mr. Tucker to arrive in court.
Includes a defendant's right to conflict-free counsel.
Okay.
The state is appreciative of the court conducting an inquiry today because case law also lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. And from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has, in fact, done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions, one being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present.
The Treehouse case is
at that juncture. It looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance.
We've got to bail on Mr. Daybell. Good luck with your attorney there.
So I see you've graced us with your appearance, Mr. Tucker. Where were you when the case was set for 1 o'clock?
I was again on my way here, Your Honor. Again, I'm not the best judge of the traffic and everything in Key West anymore. Apparently, I know I used to live here, but I also, I haven't been able to judge it. I was actually planning on being here early today, Your Honor.
Well, this is the last time, sir, because next time I'm going to issue a capias. You will be taken into custody, and we will then know where you are, because we have 14 people who were here on time, 2 more over there, 1 more over here, these people. For about the 6th time, we've sat here waiting for you, and it now is interfering with the orderly process of this trial. I have been more than indulgent with every step of the way in your plodding along and showing up late and your cavalier attitude. Be warned, next time I will grant the state motion for capias, and we won't have this problem anymore. So there's nothing need to be said other than if you need to leave earlier, whatever you need to do, be on time.
Yes, sir. Yes, sir. That's all I want to say. Yes, sir.
So in any event, we're back, and Mr. Johnson is here.
Yes, sir. I'll get him.
Wow. Okay. The judge has laid down the law. If he's late one more time, he's going to be taken into custody. And that will become very difficult to prepare for trial while in custody. I cannot stress the difficulty. Ooh.
Thank you.
Travis is
Okay,
back.
Mr. Johnson. It's
Still under oath.
afternoon, but good day in any event. So we're back here in trial in State versus Tucker, 17 CF 841. You're back on the witness stand. We're going to bring the jurors here in a moment. I just remind you, you were sworn to tell the truth yesterday, and that oath remains in effect today.
Yes, sir.
All right. Bring the jury in, please.
I would not be surprised if Travis does not own a pair of pants. Those might be his best shorts that he has on. I'm just saying. I mean, he lives on the beach. That's his life. You can't force a guy to own a suit. Trust me, I've been that guy. We do have about 5 or 10 minutes of the interrogation video left. There will be some more cross outside of that, I believe. And then we're probably going to be on to the next witness, who could be the DNA expert.
One more? Okay, well, you folks can have a seat while we're waiting for our final juror to join us from the jury room.
All jurors present in the court.
Okay, thank you. Everyone can be seated. Good afternoon, members of the jury. Good to see you all here today, albeit the beginning of the afternoon. As I told you yesterday, I did have a docket this morning, and we did accomplish what we needed to with those other cases. And so we're prepared to continue where we left off in State versus Franklin Tucker. The witness, Mr. Johnson, is here. He is still under oath, and we're going to continue with the cross-examination.
Thank you, Your Honor. May we approach the sidebar?
Yes.
Okay, calls for a sidebar first thing. His buckle on the back of the vest is undone. I'm not sure if that's intentional. It's like a tension strap on the back of the vest. Let's see. Kathy says, so Recovery Addict is a spy who doesn't own pants? I'm not going to show you my feet, but it is a no pants. It's a no pants Thursday. Let's put it that way. A Whiskey 77 Floridian. I own 3 pair of pants and it must drop below 40 degrees to wear. Flip-flop life in the sun. Gulf life. Yeah, I think I can count on one hand the number of times I've put on a pair of jeans in the last year. Now I do have some dress up clothes. I wear nice clothes. I'm the church going type, and I do dress up for church. But generally, not so. I dress up for church and funerals and weddings. And I guess if I ever go to court, I'll dress up for that as well. But I brought my suit when I went down to Florida. I brought my suit with me, thinking maybe I should wear the suit in court. But I went with a more casual look instead. I had 2 options. It was a last-minute decision. Yes, Red Pen, you've seen me in a suit. It does exist. I have a new suit. A new suit. It looks much better on me than the old suit did. Thanks for the reminder. Be kind and respectful. We do have family members, friends, close associates of people involved in this trial. Just in your comments, just be mindful of them, that they're in here and hearing and seeing those things that are said. So let's keep our comments kind. That's it. Court. What we're in court for, I was not on trial. I was in court. I went down to the Maya trial for the hearing. I think that was December 15th or something. I was down there for that one because we needed to get a feed. I had to be there in person. Let's see. You had jeans on ice skating. Yes, I did. That was the day. That was the day. Lee, I wear my birthday suit every day. I just usually wear stuff over it. Born and raised in St. Pete, Florida at 66 degrees, 66 degrees today. It's freezing. Let's just say this. Look, it's 50 degrees here right now. It's going to be 17 on Sunday in North Carolina. 17's cold. Probably talking about a little bit of impeachment material. He may have had some more that he found that he wants to go over today. It's interesting that they didn't have a sidebar before the jury came in, but the judge was using that time.
Your Honor, I've talked to the state, and apparently the rest of the video that we were watching, they believe, I believe as well, is mostly, mostly not more interviews. It's mostly, just Mr. Johnson sitting in the interview room, which I don't think would serve the jury very well. So we're going to go ahead and forego the last, I think, 10 minutes of the video.
Okay.
Okay, and in that case, I think we move on to, okay, let me grab this. Okay, Mr. Johnson, let's see if we can recap a little bit here. Now, we went over your interview with Captain Phelps, pretty great length. There's a couple other things I wanted to go over before we go ahead and excuse you. Now, you did say that you didn't go anywhere else prior to the Treehouse that day and the beach. Is that it?
As far as I can recall.
17th, right?
As far as I can recall.
As far as you can recall. You don't recall going to CVS that night?
I do not.
And you said that you would be surprised to learn if they had a picture of you outside of CVS. Is that correct?
This is what I said, correct.
We're going to add one more counter.
All going there, don't remember.
For the Capias.
Don't know about the picture they took of you. Okay. Would surprise you to learn that that's actually just prior to the incident going down? I mean, just prior to the crime?
Yes.
Now,
would surprise me, yes.
Okay.
Mr. Johnson, could you keep your voice up, please?
Yes, sir. I apologize.
And let me go ahead. Apparently the mic didn't have a battery yesterday, so I want to make sure everybody hears me loud and clear today. Mr. Johnson, if, again, you saw a picture of you outside the CVS. I said, if he saw it.
Okay, let's hear the question, so go ahead.
Okay. Just prior to the crime taking place, what would that picture mean to you?
I don't know. I don't recall it. I don't recall going into the CVS.
Oh, you don't recall. What I asked is, what would that picture mean to you? Did you say yesterday? I seem to remember you saying something like, "Get a lick" or something like that, and you described to us what that meant. Hitting a lick. That's what it was.
Yes, I described that.
Okay. And what is hitting a lick again?
As far as the vernacular, as I understand it, it means to steal something, to take something, to come up from a broke position.
Okay. And is that criminal terminology?
It's a vernacular, slang vernacular.
Okay, but is typically used in criminal terminology.
I wouldn't know if that was what that was in reference to or not. No, this is just slang as I understand it.
Okay. But you understand it as a come up. right, to get something.
I believe I explained that, yes.
Okay, good. Just making sure we're clear. Now, do you understand the vernacular of casing a joint?
Yes.
Okay. Do you understand how a picture of you in CVS just prior to the crime could be considered casing a joint?
No.
I'm going to object to the
I'm going to sustain the objection. Sheer speculation.
No. Mr. Johnson, again, you also said that, what is it? Let's take a look here. Make sure I'm correct, because I may not be. Let's take a look. You said you emptied your truck, correct, as soon as you got up to Big Pine?
Yes.
This is when you discovered your Foot Locker.
I didn't discover my Foot Locker.
No, somebody put something into your Foot Locker. I'm sorry.
After I emptied my contents in my truck into the residence where I was residing, yes. This is when I discovered the backpack in my Foot Locker.
Backpack in your Foot Locker. And you have no idea how it got there?
No, I don't.
Let's see. And when was this Foot Locker out of your possession?
Several times.
Okay. Now, looking at the dates again, did you, you said that I helped you put your Foot Locker into your truck. Do you remember what date that was?
The date that I left.
Okay. So,
This
that
is
would have
still
been
cross-examination.
What, 22nd? Oh, I'm sorry, no, it wouldn't have been on the 22nd. That would have been on, what? Yeah, that would have been on the 21st. Is that correct? Did that sound about right?
That sounds about correct, yes.
Okay, good. Because you said the day of the raid, right?
The day after, like the morning after, yes.
Morning after, so that would have been the 22nd. I'm just trying to keep our timeline here. Okay, so 22nd is when you moved. And supposedly I helped you move this Foot Locker. I seem to remember, let's go with my memory. Now, after the raid, I wasn't there, correct? I was at the police station.
I guess they took you into custody, yes.
Okay. Yeah, well, actually, you wouldn't have known where I was, that's true. Okay, so but I wasn't there, right?
No.
Okay.
Not when I got back, no.
Okay, and did I arrive sometime later?
Early that morning.
Early that morning. Do you remember about what time?
No.
Okay.
Before sunrise.
Before sunrise. Okay. And do you remember me saying anything to you after I got back?
No.
Don't remember anything. Did I have to wake you up to open the door?
No, I don't believe so. I don't remember.
Okay. You did have the only key, correct?
No, I didn't.
Well, you said Rory Wilson had a key.
Yes.
Okay, but Rory was, to your knowledge, was Rory Wilson, man? Was he actually still in jail at that point?
Yes.
Okay, so he didn't. Again, obviously his key would probably be there with him, correct?
I don't know.
Or, again, would I have access to it? Most likely.
I don't know.
Okay. Actually, let me rephrase this. This is too much supposition.
I thought we covered this yesterday. This is all repeat testimony.
Well, I can't say with certainty, so we certainly
Thank you.
aren't going to cover what has already been asked and answered, but thus far I can't say with certainty that's the case.
Thank you. Let me go ahead and get this a little bit better. Because I want to do that. Let's go here. All right. Okay. Let's see what we've got here. As far as
He's on Google.
Okay. We've already covered the routes. We've already covered the knowledge. Okay. Again, could you do you happen to remember your phone number from that point in
We're
time?
going to mute this part.
Okay.
If he says it.
Again, did your lawyer again make you privy to any of the discovery concerning phone records?
No, not concerning phone records.
Okay. Now, in the video, we did see the detectives, and if I remember right, did you? And I would imagine you saw with us the detectives discussing your phone calls with Rory Wilson.
Yes, I remember that.
Okay. and they discussed how your phone calls were right around the time of the crime, correct?
I don't remember what time the phone calls were, no.
Okay. You don't remember when we watched the video what times they were talking about?
No.
Okay. Would it surprise you, again, I think you said your answer, again, I'm trying to clarify here because my memory may be messed up. I think you said that you told the detectives, did you tell the detectives something like we were just talking, or we're just talking or something like that?
Again, I don't remember the conversation.
Okay, not even after the refresher we had?
No.
Okay. I don't know if we want to go and repeat the video, but I don't know, we may have to. Now, let me converse with the state, if you wouldn't mind, for just a second.
We should mute this right here. We shouldn't be able to hear any of this conversation. Go in sidebar. That means the state's objecting. They're not a big fan of what he's trying to do. He seems to be trying to get his footing as far as the line of questioning today. The responses from Travis have been basically, I don't remember, not sure. Really hasn't given him any foothold to launch from. Obviously, Travis is much more calm and relaxed today than he was after the questioning yesterday, which really triggered him quite a bit. But I think the judge will object to showing the same thing again for the same purpose. I mean, how many times can you refresh a witness's testimony using the same thing and then he forgets about it and then you keep refreshing it? That would be, it would seem like he's going back on the same thing. So I think the judge will most likely side on the part of the state here on this request, on this sidebar. It is an objection, but the judge is pantomiming the actions to the old Excedrin commercial right now. I had a headache this big. I did like that the judge said since he doesn't recall this being covered directly last time that he let Tucker go into it again. I think that was fair instead of just taking the state's word for it. Smiles from the state, which means they're probably winning.
Let's try this again. Mr. Johnson, do you remember watching the video yesterday?
Yes.
Okay. Do you remember the section where the detectives are talking to you about your phone calls with Rory Wilson?
Yes.
Okay. You don't remember the context of that conversation, or do you remember what you said in that video?
I don't remember what the phone calls were about between me and Rory Wilson. And I do remember in the video me saying the same thing.
Okay. You saying the same thing in there?
Yes. Okay. But I don't remember what the context of the video, of the phone calls were. I still to this day don't remember.
Okay. But you do remember the context of the video, right?
Yes, of course. Okay.
And you do remember the detectives asking you, or again, asking you in reference to the time frame of those videos or of those phone calls?
Yes.
Okay. And how it is around the same time of the crime, before and after?
I remember the video, correct, yes.
Okay, so you remember them saying that?
Yes.
Okay, good. Okay, and now you said that you were in a hurry to get out of there, right? You wanted to get out of the warehouse, get away from myself and Mr. Wilson.
Yes, I said this.
Okay, and so you were in a hurry to get out of there.
My understanding of the word hurry is to move as quickly as I possibly can.
Well, then you agree on that. What would you consider as quickly as you possibly can, considering that, again, you had learned that it was a homicide?
The time frame references between here and now, I really don't know how to answer that question for you.
Okay. Would you consider, again, you said you left the crime scene because you were scared and wanted to get away from the situation. I'm asking you, how quickly would you want to move out of the warehouse where you were still being subject to myself and Mr. Wilson, still being there?
As quickly as I could.
Okay. And as quickly as you could, would that mean a week, a month, a year?
Unfortunately, I'm not a fortune teller and I can't see the future, so I have no idea how long it was going to take me. I had no clue how long it would take me, and I had no specific time frame to reference to how long my hurry should take.
Okay.
I'm sorry.
Okay, would it surprise you to learn that the day after the crime, you had about 10 phone calls with Mr. Wilson?
No.
Okay, doesn't surprise you?
No, I don't remember these phone calls.
Okay, you don't remember those phone calls?
No.
Okay. Again, you moved out, was it the 22nd we agreed? Okay, so the 22nd, so the 17th to the 22nd, that, you know, my count, that's what, 1, 2, 3, 4, 5. So 5 days, and she moved out, correct?
Correct.
Okay. And what were you doing in the meantime?
What people do to try to get out of where they're at.
Okay. What did you do to try and get out of where you were at?
Scheduled appointments with individuals that my girlfriend and I could acquire for me to get work, perhaps shelter,
okay,
residence. These things take time.
I would understand that, and under normal circumstances, yes, that would probably be the case. What I'm asking you is, under the stressful circumstances that you were in, does 5 days seem like a long time?
Judge, I'm going to object to the question.
This has already been, we've already gone over this multiple times, so I'm going to sustain the objection.
Again, how many conversations did you have with Rory Wilson after the crime?
I don't remember.
You don't remember? Do you remember any of it?
No.
You don't remember talking to him at all?
No.
Okay. And, you know, let's see. You did. You said you didn't see Rory Wilson after that, though, correct?
Okay. What?
You didn't see Rory Wilson after the crime?
Yes, I did. I walked with him back from Tom Thumb.
Walked back with him from Tom Thumb, spent the night with him there, correct?
Yes. The next few nights until the raid happened, yes.
A second, partying, correct?
For one night, yes.
Okay. And does that seem like the actions of somebody who's scared?
Do you understand what the actions of somebody who's scared are?
You have to just answer
I would like an answer.
Not with a question.
I don't know how to answer your question. Yes, no, yes.
All you need to say, if you don't understand the question, you don't know how to answer it, just say that.
I'm just trying to understand.
We know, so let's just go on with between the two of you, question and answer. That's what we want.
I would like to understand, Mr. Johnson, why, if you were afraid enough that you took off and, you know, left the crime scene the way you did, that you would sit there and party with these people when you got back.
Objection, Judge.
Yeah, I'm going to sustain the objection.
Okay. All right. So we established that, you know, the very first, you know, the crime afterwards.
Okay. I'll overrule that. But
okay. Thank you. All right, Mr. Johnson. Okay. After the partying of that night, again, did you see Mr. Wilson after that?
I saw him up until he was arrested at the raid.
Okay. You saw him up until...
Periodically, like, coming and going, yes. As well as you.
Did you have any conversations with Mr. Wilson?
In passing, I don't remember specific conversations, no, but I'm sure that we spoke.
Okay. And you said that he held on to some of your belongings for you while you were in jail. Is that correct?
I said that he said that.
Okay. And did he, in fact, hold on to some of your belongings while you were in jail?
If you want to call it that, yes.
Okay. And I don't know. What would you call it, Mr. Johnson?
Theft.
Okay. So you're saying he stole from you while you were in jail?
That was my belief, yes.
Okay. And again, you know, did you inform the police that he stole anything from you?
This is what I informed them that could have happened. I don't know if it was him or not.
Okay.
The investigators are the ones who were determining that. This was the only information that I could give them, is what I believed from what he told me and where my belongings were. This is what I told them.
And you told this to the police when you filed your report for robbery, not after
the day it happened, with the individuals, the officers that came when I called the police. That's who I told this to.
And you told them that Rory Wilson stole from you.
I told them I believed that the individual on the steps stole from me.
Did they question Rory Wilson?
I'm going to object to the relevance of this line of question.
I'll overrule the objection.
Thank you. Did they question Mr. Wilson at all?
No.
Okay, they didn't question him. And did you, in fact, ever get any of your items back from that?
No.
Okay.
Not the ones I reported stolen, no.
Okay, but that was the guys they used when they brought you down to the station, correct?
Correct.
Okay, but you didn't get any items back?
No.
Okay. And you said, again, that you emptied your truck. Okay, when they went to search your truck, if you emptied it, why would there be items still left in there?
When my truck was searched by the police, this was months after I had been arrested. Months after I had been arrested. My truck had been towed from said residence and packed by whoever didn't want my stuff in their home anymore into my truck to have it towed to Mr. Martin Ochoa's residence. That's where the search was conducted, not at the time or point of my initial contact with police.
So to be clear, just to be clear here, your truck got towed from the residence you were at to Mr. Martin Ochoa's home. Is it a home or is it his business or something?
His home.
His home. Okay, so it got towed to his home with your belongings in it, correct?
Yes.
Okay. And you said this happened, the search happened months afterwards.
Yes.
Okay. Now, did anybody else, to your knowledge, have access to your truck at that time?
Everybody that possibly wasn't me.
Okay.
I was in jail.
Everybody but him.
Okay. When the tow truck actually took it, did you have the keys, sir?
The keys were in my property. I did not have them, no.
You didn't have access to the keys?
No.
Okay, so that would mean the police had access to the keys or somebody else?
They were in my property.
Okay. And we did have the privilege of talking to former Detective Malone, who conducted the search on your truck. I think she described it as a lot. Does that sound correct to you?
A what?
A lot. You said it was Mr. Ochoa's home. She described it as a lot. Was it a lot?
I don't know. I've never been to his home.
Okay. And did you ever find out what happened to your truck after the police searched it?
It was repossessed by the bank.
It was repossessed by the bank. Okay.
Correct.
Okay, so you have no idea what happened to it after that?
Correct.
Okay, good. Now, again, amongst your belongings that they brought out in the search was, I believe, an extensive knife collection, if you want to call it that.
Yeah. Yes, it was.
Extensive. And if I seem to remember correctly, you like to take care of your knives. Is that correct?
I'm a blade collector, of course, yes.
You're a blade collector.
Yes.
Okay, and do you like to sharpen your knives and oil your knives and such things? Again, I'm not a very knowledgeable person in this thing, but I seem to remember that was something you liked. Is that correct?
Yes.
Okay. And would it surprise you to know that the residue from those things can be detected? The oils, the stone.
The stone.
And when you sharpen the blade.
Yes.
Okay.
I guess.
Okay. Well, again, now you said that the knife that has been used in this crime, you said that belonged to me, correct?
No, I did not.
I seem to remember you. Who did it belong to then?
I don't know.
Okay, you don't know.
No.
Okay. Okay. I'll save that one for redirect. Again, with the knife, you seem to have great detail when describing it in your interviews. How familiar were you with that knife?
Familiar enough to think that it was a dive knife.
To think that it was a dive knife. Did you know the color? Did you know the handle? Did you know the blade?
Yes.
Okay, all of those things.
Yes.
Okay, and again, how many times have you been in contact with that knife prior?
Once.
Once?
Yes.
Okay. And how long a period of time were you?
I don't recall.
Wait. Let him finish the question.
How long a period of time were you in contact with this knife?
I don't recall.
You don't recall?
No.
But enough to know the details of it, correct?
Sure. I'm interested in knives. I try to remember them.
Okay. So, but it doesn't take very long.
No.
Okay, cursory glance maybe?
It depends.
Okay. Okay. Let me go ahead and we're going to go ahead and, subject the witness to recall, I'll go ahead and let we can end this and go for redirect, Your Honor.
Okay. Well, when you say subject to recall, you're talking about in your case. Is that what you're saying?
Yes, sir.
Mm-hmm. Well, I guess the cross-examination is concluded.
It's concluded.
So, state would like redirect examination.
There will be redirects. Did get the vibe that there was some selective memory issues going on here. With
Judge, before I get started, I do want to move into evidence the video that the jury watched during the cross-examination. I have it marked here. Okay, I have it marked as P as in Papa. I'd seek to move this into evidence.
I take it there's no objection?
No, sir.
All right, admit as the state's next in order. Number, what is it? 13. 13. I thought we already had 13. I thought we were up to 15. All right, admitted state's 15.
All right, now the state's 15 is in evidence. Just put that in, please. I'll be referring to some portions of the jury correct, Judge. That's why I want to make sure it's queued up.
Nope, the jury decides on the impeachment. The judge rules
Travis,
what's allowed in.
A couple things I want to clear up here.
Yes, sir.
I like it when you call me Big Papa. There's a song there.
You said, way back in the beginning, you said you came to Key West, you actually advertised, was it on Facebook?
Yes.
And you advertised for what?
For a position as a painter.
Okay, and did you receive calls through that advertisement?
I did.
All right. Can you say for sure whether you did or did not receive a call from this defendant during that early time in Key West?
I cannot say no.
Is it possible you received a call from him not knowing who he was or not knowing what your future with him would entail?
Possible.
Okay. So the first time you remember meeting him is when?
When I got out of jail.
And you were living at the warehouse?
Yes.
And when you first met him, where was he?
At the warehouse.
Was he with anyone at the time?
He was with Detroit Wilson, Rory Detroit Wilson.
And that's the other one that's involved in
One
this
of the
plan
three
this night of
Detroits.
this robbery. Now, Travis, you agreed to get involved in this, I guess, this plan, and your expectation was to what? What did you expect to get out of it?
Gas money for my truck.
And at that point in time, are you familiar with the legal concept of the principal theory?
At this time, no.
Did you know that you could potentially be held liable for anything that happened inside of that treehouse, even though you were only the getaway driver?
No, sir, I did not.
Now, the plan, to be clear, was to go in there to commit a robbery. Is that right?
Correct.
And again, what was the goal in going into that treehouse that was discussed between you, this defendant, and Rory Wilson?
To get the money in the crack that the resident had.
And again, that lead came from somebody at the Burger King. Is that right?
Correct.
Now, you said several times that lead was brought back from Burger King by Rory Wilson, right?
Correct.
And then at one point, I think on one of the tapes, you said something about Tyrone. Is that right?
Correct.
Was that a misspeak on your part?
Yes, it was.
As you sit here today, do you remember who brought the lead back to the
Yes, I do.
to the warehouse?
I do.
And who was that?
That was Rory Wilson.
All right. He brought the lead back, and who did he share that lead with?
Mainly with Mr. Tucker.
And
me.
And you?
Yes, I was in the room.
Okay. And at some point, you got involved in the plan to go over there?
Yes, I did.
Now, there seems to be a little confusion on the cross about how many trips over to the Treehouse were made prior to the actual robbery. So let's be clear. You testified that you guys went over there and did, I guess, for lack of a better phrase, a drive-by. Is that accurate?
Yes.
And after the drive-by, were there people or cars at the Treehouse at the time?
Yes.
And you guys went back to the warehouse?
Yes.
And when you went back to the warehouse, what was the purpose in going back to the warehouse?
For clothing.
And about how many minutes later, if you can estimate, did you guys head back over to commit the actual lick?
I feel like about 5 to 15 minutes. I'm not 100% sure of the timeline.
Okay. Now,
to commit the actual lick. The evidence in this case is open because it's been used in the trial against Rory.
number 7, it's in evidence from the court. Chris, let's go into the electric one. Or let's go into the other one first, the Cosme. David, if you could help me. Which ones? Yes, I got it right here. Which video is that?
Kathy, there's a certain kind of ice cream
Chris,
that's better than any other. I'll tell you in a minute.
1943.
It's called Cookie Two-Step. It's really good. It's a mix between chocolate chip cookie dough and cookies and cream. Delicious.
Travis, it's coming up here, 1943 and 22 seconds.
We can all see the video here. Pay attention this time, guys.
Perfect. Okay, right there. Is that consistent with your truck pulling over the Treehouse?
Yes, sir.
All right. And is that consistent with what happened on the day, November 17th of 2017?
Yes, sir.
Now, on this is your initial approach. Is that accurate?
Yes, sir.
Did you guys stop or did you continue going after that initial approach?
I continued going.
And again, if you can refresh the jury, why did you do that?
Because there was somebody there.
All right.
Or is this is the first one? No, this was the initial drive-by.
Not the initial, right?
This is the one before I stopped and they got out.
Okay. So after leaving the warehouse when they were dressed in black and with weapons, this is your first approach after you left the warehouse?
Yes, correct.
Now, if you look to the right of this boat, between these two boats, back in this area, we see your truck go all the way through. Is that correct?
Yes.
Now, there's some talk here. There's a glare there, right, on the front of this boat?
Yes, correct.
Do we know where that glare is coming from?
No, sir, we do not.
It's obviously not your headlights, right?
Obviously.
I mean, where's your truck at this point?
Not there.
Is there a glare coming from this window?
That's a light.
A light?
Yes, that's a street lamp at the CVS.
Okay. But the glare that we're seeing there, is it fair to say that's not coming from your truck?
Yes, this is fair to say.
Because your truck at this point is where?
Not there.
Okay, not there. Where is your truck? Tell the jury where your truck is right now.
Driving around the block.
All right, fair enough. Okay, Chris, if we can go to, actually, just let it play. it's going to be 1945. Chris, if we can just advance 1945, that'll...
Your Honor, may I move up a little bit closer so I can see here?
Yes.
Thank you.
Thought he was going to object.
And Travis, I'm going to again have you focus your attention to the left of that big boat that's in the middle of the frame.
Yes, sir.
Do you recognize that?
Yes, sir.
What is it?
My truck.
Okay, now it's a minute and a half, 2 minutes later, right?
Correct.
Minute and a half later?
Correct.
All right, would this be consistent with you reapproaching the treehouse after the first drive-by?
Correct. Yes.
Chris, if you just play for me. Now focus your attention over here. Keep going. Pause. Can you tell for sure where your truck is at this point?
100% no.
Now there's a couple different glares going on here, right?
Yes.
Chris, if you can back up for just 3 seconds. Okay, number 1945. Is that you there?
Yes, sir.
All right, what's what we just saw? Go ahead, Chris. Focus over here, Travis, if you would. We can see a flash from your headlights as it approaches. Is that accurate?
Yes, sir.
But do we know where the truck is stopped at this point?
No, sir.
Kind of hard to see in this video?
Yes, sir.
Now, we still see a light going on here, right?
Yes, sir.
Is that coming from your headlights?
Probably not, sir.
Okay. Now, your testimony is that this defendant and Wilson got out of your truck, right?
Correct, sir.
Is that consistent with what we see there?
Yes, sir.
All right. And that's at what time now? 1945 and 40 seconds.
No, fully blocking the picture.
And Chris, would you take us to 1951, please? Travis, if you look over here, do you still see a light over here?
Yes, I still see a glare.
Where's your truck at this point?
It's still sitting right there.
Is it in, can you see this frame or not?
No, sir.
Now, we just saw somebody run up the hill. That's, we said before, that's what Quinn, correct?
Correct.
Right there. And again, who do we see running there dressed in black?
That's Mr. Tucker.
The defendant.
Yes, correct.
And you didn't see Wilson leave?
No, sir, I did not.
All right, Chris, I'm done with this one. Let's go back to the clerk.
In the Chad Daybell case, the judge is saying if he allows John Pryor to leave, to withdraw, it could delay the case by at least a year.
All right, Chris, that's one. All right, perfect. All right, I'm going to bring your attention to some times here in a minute. Now, all right, Travis, so we've covered the videos from the night of the event. I want to go to what was going on with you after they brought you down to the station under the guise of looking for your items from your truck.
Yes, sir.
Now, you got to the station that night, right?
Yes, sir.
Initially, when they switched the script on you and they started asking you questions about what happened at the Treehouse, were you surprised by that?
Yes, sir, I was.
Did it catch you off guard?
Yes, sir, it did.
And initially, during your conversation with them, did you come clean right away and give them
No, sir, I didn't.
own up to what you had done?
No, sir, I didn't.
What were you doing?
I was backpedaling. I was scared. I was processing in my mind what avenue I wanted to take.
And so, as they asked you questions, were you being 100% truthful with their answers?
No, sir, I wasn't.
Were you trying to mislead them or diffuse them?
A little bit, yes.
Were you worried about minimizing your involvement in this crime?
Yes, sir, I was.
Again, at this point, were you familiar with the principal theory?
No, sir, I wasn't.
Were you familiar with the idea that you could be held accountable for everything that happened, even though you were in the truck that night?
No, sir, I was not.
As they questioned you, did they start to confront you with more and more evidence that they had in the case?
Yes, sir, they did.
Now, you specifically testified that Phelps put it together, right?
Yes.
She's the detective or the lead that was in there?
She was the captain, yes.
The captain, okay. And you said on, I believe it was on direct and on cross yesterday, she nailed it 100%.
Very smart detective, yes.
When she went through the events with you, were you surprised at how close she was to the truth?
Yes, sir, I was.
And as she talked to you, and we saw it in the video yesterday, did she present you with her theory of what happened?
She did.
Okay. Now, let's go, Chris, if we go to 2019, please. It's at 2019. I'm not sure which one it's going to come up on. Maybe that one. Okay, no, we got to go to 20 and 9 hour 2019 minutes.
I mean, I'm like full time. Without one key. And key list. Yeah. I talked to you 2 minutes ago.
And do you want some water?
Yes. And my field, we've been able to verify. This guy, stop up in his head, but there, we'll get out. You just, whatever. Okay. I don't think that was going to have just look like with all that you see, I don't know where you're from. Yeah. Once you get to my city truck, it'll be, but razor burn. See, but just the night by itself, it was not yet. We just look at the last night. Oh, command just went down. Like service, was in the shirt. How
Okay, Chris, go ahead and stop.
20, 10s, 5s, 20, and 5s.
And pause, Chris.
When you saw how to run,
Now, we're at the point of the interview where you were talking more clearly with Captain Phelps. Is that fair to say?
Yes.
Are we at the point where you have decided time to come clean?
Yes.
What brought you to that decision, Travis?
Actualization of the fact that somebody was dead and I was responsible, and that I wanted to make sure that this was resolved.
Now, at that point, you decided time to own up to it?
Yes, sir.
And is that what we saw in the video yesterday where you got very upset? I think you had a moment where you really got overwhelmed?
Yes.
Why is that?
actuality, reality slapping me in the face.
The reality is that you were involved in an event that turned into a homicide.
Correct.
Scary stuff, right?
Yes, sir.
Now, you're talking to Captain Phelps, and she's asking you about the knife, right?
Yes.
Did she tell you what the knife looked like?
No.
Did you tell her what the knife looked like?
I did.
I mean, they knew a knife was involved, right?
Yes.
The guy had been stabbed to death, right?
Yes.
So when she asked you about the knife, did you describe the knife?
I did.
And how did you describe it?
I described it the way it looked, the way it is.
Black and red?
Black and red with a serrated edge. Yeah, black and red with a serrated edge and a smooth edge on one side and a silver pommel on the bottom.
Had you seen that knife before?
Yes.
How many times had you seen it?
Once or twice.
Where did you see it on the night of the Treehouse stabbing?
And I saw it in the house, and then I saw it in Tucker's hands.
Tucker's hands?
Yes.
You guys sit right there?
Yes.
It's in his hands when he came out of the house?
Yes.
Dressed in black?
Yes.
With gloves on?
You're telling Captain Phelps. Now, when Captain Phelps was asking you about details about the knife, did she show you the knife?
No.
All right. You told her what color was the handle?
Black and red.
All right. What about the blade? Did you tell her about the blade?
Yes, I did.
What did you say?
Serrated on one side and sharp on the other. Smooth on the other.
Serrated on one side, sharp on the other. Throughout your interview with Captain Phelps, what did she tell you she wanted from you?
The truth.
The what?
The truth.
The truth, right?
Yes.
Did she say it more than once?
Yes.
Matter of fact, at one point, doesn't she say to you, tell us what happened, and your response to her is what? You just said it.
Yes.
Right?
Yes.
When you said you just said it, what were you meaning when you said that?
I was meaning that she knew the truth. She had, through her theory, for lack of better words, nailed it. And
what was
she
her?
said it.
Do you recall what her response was when you said you just said it?
She said she needed to hear it in my words.
She wanted to hear it in your words, right?
Yes.
You tell her what happened, and then you went and you started telling her exactly what happened. Is that fair?
Yes.
At 2020, Chris? Yes, please.
He's skipping ahead a couple seconds at a time.
And I'm going to let it play for a couple minutes because then there's a couple things within the next 2 minutes I want to talk about, okay?
Do you trust, do you know who killed the guy? Did they ever tell you? If one person that was stabbed, who would you think would have done that?
Pause, Chris. She asked you if you knew who stabbed the guy, right?
Yes.
And she asked you if you had to guess, which one would you say?
Yes.
And what was your answer?
I didn't know well enough to develop a guess. I didn't know either one of them well enough to know who had done it.
Did she give you the name of Tyrone Tucker, or did you offer the name?
I offered the name because she said that I knew who did it, and I think I offered it in the form of a question.
So you offered the name of Tyrone Tucker, not Penny Phelps.
Correct.
You're the one that brought that name into this narrative. Is that fair to say?
Yes, sir.
Not Penny Phelps.
Correct.
So when the defendant says this was her narrative that you simply endorsed, that's not accurate, is it?
No, sir, it's not.
Go ahead, Chris, play. Chris, why is the video not?
Dang it, Chris. You got one job. You're gonna have to reboot the computer. But I turn it off and back on again.
The video's not buffering, I'm told. It's the same as the audio, but the audio is what's important to me at this point. The jury's going to be able to look at this. It's in evidence. So let's just go with the audio. Chris, go to...
Can we sidebar for a second?
Yes.
Mr. Tucker objects. I wish he'd put these on the record, but it's all right. He's not playing the courtroom chess game. as well as I'd like to see him. He has to wait for the other side to be there before to talk to the judge. But okay, now he can begin. Apparently Zoe is here. Got a visitor. So Zoe's allowed in the house, but the cat is not. How is that fair? We're not allergic to Zoe. Oh, that's because Zoe gets haircuts and doesn't shed. Let's see. Let's see what the problem is here. Judges typically allow quite a few sidebars, because a sidebar is usually to prevent a big problem later on. So it's easier to have a sidebar than to try to put out the fire after the fact. Looks like the sidebars are recorded. The clerk's got a recording machine up
Chris,
there.
if you go ahead and hit play then.
Or microphone. I've not seen that. Did he release a statement?
And so it's $200,000. That's pretty messed up, guys. Pretty messed up.
Chris, can you turn it up at all? Okay.
Before the robbery happened, what did you think was going to happen if you told them, no, we're not doing it? What did you think was going to happen?
Nobody can hear this.
You know, the fact that they're talking about it, I'm not going to agree with something like that. They can't trust me. They don't, you know what I mean? Now I've got to worry about really sleeping in that place. I was nervous. I thought I needed to. Okay. To tell them, you know, that I would have to. What did you think they would do if you didn't go along with it? What do you think was going to happen? You know, with all my stuff would have been, you know, stolen and whatnot, you know, maybe beat up, I don't know, this done. Okay.
Next piece.
Yeah. So what I'm saying is making a decision right here, you're afraid. No, do you know what was going to happen? Okay. I figured like I just needed to go along until I could get an opportunity to get out of there safely.
He's describing his reluctance to participate in the crime.
Safely, it's just working where my stuff is. Earning my living and going on my life.
Excuse me, you building up to a question here, or just?
Yes, Judge.
Okay.
All right, Chris, go ahead and pause. I was hoping to get to the part, Travis, but let's just talk about it. At one point, you offered to draw a map. Is that accurate?
Yes.
And what was that map? What were you requested to draw? Or what did you request to draw when you wanted to draw a map?
The route.
And did Captain Phelps tell you what route you took?
No.
Did you tell her what route you took?
Yes.
Matter of fact, at some point, she says something on the map, and you correct her, don't you?
Yes.
She's pointing in the wrong direction, and you actually corrected her as to which direction your truck was going.
Yes, sir, I believe it was.
All right. At that point, is this your narrative or her narrative?
Mine.
Yours, right?
Yes.
You gave a detailed description about the planning of the robbery, correct?
Yes.
Did they know about the details in the plan?
No, sir.
Where'd those details come from?
They came from me.
What about the details in Rory Wilson's mask? Is that something they provided to you?
No, sir.
Where'd that information come from?
They came from me.
What about the gaiter that this defendant was wearing? Did she provide you with that information?
I'm sorry, what's the objection?
There's been established those wearing anything.
Well, I disagree. That might be a point of contention, but it's a legally cognizable question, so I'll overrule the objection.
Let me ask it again, Travis. So the gaiter that this defendant was wearing, did Phelps give you details on that?
No, sir.
Where'd that information come from?
It came from me.
Now, describe the defendant. He looked different back then, 6 years ago. Is that accurate?
Yes.
Tell the jury about how he looked. Did he have a bigger goatee, smaller goatee?
He had a goatee about this long. Straight
Long.
down. Long.
All right. Did he have a full set of teeth?
No.
And the gaiter that he pulled up, does that cover his goatee?
Yes. Yes. I apologize.
The knife you gave the details on, is that fair to say?
Yes.
Now, the money that you got, you said it smelled like perfume.
Yes.
Is that something that they told you, or is that something you gave to them?
Something I gave to them.
This does not convince me of anything. If the defendant
brought up the
witness was
scenario
involved
about April Walker,
and Tucker was
again,
not,
who was
he would
April
still know
Walker?
all these facts.
Rory Wilson's girlfriend.
Rory Wilson's girlfriend. Was she living at the warehouse as well?
Yes.
The defendant asked you about these threats and the timing of these threats. Do you remember on cross?
Yes.
When you left for Big Pine, was April still in that warehouse?
Yes.
And you said to the defendant when he asked you, she didn't appear to be nervous or scared, right?
No, sir.
I believe that's what you testified to on cross.
Yes.
Now, you were up in Big Pine for at least a day, then they brought you down to the station, right?
Yes.
In that tape, when we see Captain Phelps come into the room and tell you that April Walker's nervous and scared, is that before or after you left the warehouse that morning?
After.
After, right?
Correct.
So when you left the warehouse, had April Walker received those threats?
Not as far as I know, no.
When Captain Phelps came in the room, what did she say?
She said that April had received threats.
Had just received threats.
Just.
The defendant also asked you about whether you saw blood on him or on Wilson that night, right?
Correct.
What color clothing were they wearing?
Dark. Black.
Is it easy to see blood on dark black clothing?
No, sir, it's not.
Were you looking for blood on them that night?
No, sir, I wasn't.
Had you suspected that somebody had been stabbed to death inside the treehouse?
No, sir, I hadn't.
So when you walked with Wilson back from that CVS, I'm sorry, I apologize. When you walked with Wilson back from Tom Thumb, were you looking at his body to see if there was blood on it?
No, sir.
When you and this defendant were in the warehouse right afterwards, and this defendant was mad at you for having left him, were you looking at his body for blood?
No, sir, I was not.
Again, what color clothing was this defendant wearing?
Black.
After you left that place in Big Pine, you said your truck was empty when you left, right?
Correct.
And you had unpacked the stuff into the house, right?
Correct.
Then the police came and looked at your truck, right?
Correct.
And then they invited you to come down to the station and look at this other stuff they had, right?
Correct.
Did you ever see your truck again after that morning or that day?
No, sir.
So when you left Big Pine, you never saw that truck again?
No, sir, I didn't.
When you left Big Pine, was the truck empty?
Absolutely empty.
So how did you find out that somebody had taken all your stuff out of the house and put it back in the truck?
When I received the search warrant affidavit.
Okay. Were you surprised to find that all that stuff was in your truck, or did you figure that's what was going to happen with your stuff?
I figured it was, I really didn't know, but yes, I was surprised to know that it all had been piled into the bed of my truck.
Now, you are a knife collector, right?
I am.
You had a pretty extensive set of knives. Is that fair to say?
Yes, sir.
And were those knives back in that truck again after they cleaned out the house that you were staying at?
Yes.
Or that you were going to stay at, right?
Yes. Yes, the knives were in my possession when I went to that house, correct?
Okay. Now, when you finally decided to own up to your involvement, that's when you, I guess, came clean with the detectives, right?
Yes, sir.
Did you do that before or after they showed you the videos from the electric company and from the Cosme Marina?
Before.
So those videos that this jury has seen, you were not shown those until after you gave them your statement. Is that accurate?
Correct.
It's been 6 years. Can you still in your memory clearly see this defendant running from the court, the treehouse that day?
I can.
You guys take a step back.
The defendant asked
Got
you
some people
today,
that just need
you
to
wanted to
not
get out
type
of
for
there
a little
quick,
while.
right? You were scared, you wanted nothing to do with this, right?
Correct.
But you still wanted to get high, right?
Of course, that's the insanity of addiction.
So you weren't about to leave until all the drugs had been smoked, at the very least, right?
Correct.
Let's talk about these deals. You came in and you gave statements, right?
Yes.
And we just went through the one that you gave to the detectives back in 2017. Is that fair to say?
Correct.
We played that pretty much in its entirety yesterday, right?
Correct.
Now, in April of 2022, you were approached again about potentially becoming, or potentially entering into cooperation with the state.
Correct.
And before we talked about any deal, did you in fact give another sworn statement?
I did.
And that was prior to any deal being made. Is that accurate?
Correct.
Judge, at this time, the state is going to move into evidence what has been marked as P as in Papa.
Objection.
Well,
We already did C.
It's already been marked.
what? P has been admitted into evidence.
Oh, because then it's O.
He's objecting here.
Your Honor, name is sidebar again.
Well, in a minute. Right now, I'm going to set the stage or let the state set the stage for whatever they're doing, and then we'll...
Okay.
So where's the, you want this one in evidence now? Is that an objection or?
Well, do we have an exhibit that's marked?
Yes, Judge.
What
It's
is
marked
the-
O as in Oscar.
Okay, and what are you doing with it?
Seeking to move it into evidence.
Okay, is there an objection?
Yes, sir.
Okay, so now we'll approach the bench.
Now we have the sidebar. He's objecting to the evidence. I didn't hear what this evidence was. Let's hear what this is. O is an objection. It says Greeners, yes, it's marked O. Let's see what this is. He didn't say what the evidence was. He just said at this point we're going to introduce this. I didn't hear the foundation for this to be brought in at all. It's another statement offered apparently before he agreed to a deal. Quick decision by the judge.
Conference won't accommodate.
It's the deal. Is the jury going to be leaving? Is that why everyone's standing right now? Teresa, thank you for being a member. Love that blue courthouse.
Okay, the jurors are gone. So first of all, I don't know what O is. I mean, you ask the witness if he remembers back in, I think, April 2022, making another statement, and moved O into evidence.
Yes, sir. So, Judge, I'll let me explain. In April of 22, when we approached the defendant about potentially doing a deal with him, we said before we talk about anything, we want a sworn statement. And he gave us a sworn statement. Normally, that statement would not be admissible. It would be hearsay. However, under Rule 90.801.
No, wait a minute. So O is some...
O is that proffer that he gave, an audio of the proffer or the sworn statement that he gave to my office.
The defendant or the witness?
So you're moving it into evidence on Mr. Tucker's objecting, so let's hear what the state's basis of admissibility is.
90.801, subsection 2, subsection B.
Treecom Junkie OG, welcome.
A statement is not hearsay if the declarant, Mr. Travis, testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. This defendant has been attacking this witness now for a day and a half about, you'd do anything to get out, wouldn't you? You'd say anything. You even said in the video, I'll do anything you want. He has made allegations of a fabrication on this defendant in order to get a deal. He's made allegations of improper influence of Penny Phelps. And he's made allegations of the motive to do it, meaning this defendant did not want to go to prison for life. So basically, he's here saying anything he has to say in order to avoid that. That's specifically what this rule is meant to address. So normally, a prior consistent statement would not be admissible, but now that that has been established, it is my position that statement should be admissible as a prior consistent statement offered to, to rebut allegations of improper influence, motive, or recent fabrication.
And the defense's position is? The defense's position is that, again, as far as his motives, as far as the deal he cut, yeah, that one is self-explanatory. I didn't have to point that out. As far as Ms. Phelps, is she going to be addressed in that statement? The statement that you're trying to enter into evidence on cross? I mean, not a cross, I'm sorry, on redirect. You're trying to introduce new evidence into redirect, and does that actually does it say anything about Penny Phelps?
I don't know.
Because, I mean, that's what he's using to establish this law here. He's trying to say that, you know, because we question Mrs. Phelps's motives, that would establish this law.
It's not a question of Phelps's motives. It's a question of this defendant, or this witness's motives. He has been alleged to have fabricated this story in order to get a deal. He is alleged to have been improperly influenced in order to provide this story. This is specifically what this rule is designed for. It is specifically designed for a witness such as this who has been attacked by his motive for testifying, the content of his testimony being improperly influenced, and that it was fabricated to get a deal.
But does it allow you to enter new evidence on redirect?
Well,
Judge, I'm not teaching law to the defendant, so.
We're having a legal argument. This is exactly what when this whole business about the defendant wanting to play the interview, interrogation, whatever you want to call it, of Johnson with Penny Phelps, this is what I don't want to say warned about, but acknowledged that the door may be opened.
Yes, sir, that is correct.
Excuse me?
I said I understand, Your Honor.
Okay, so now the question is this within that rule? So what's the rule?
Judge, it's 90.801, parentheses 2, subsection B.
Judge is reading the rule. I wonder if the judge...
What subsection?
B.
I'm sorry, Judge, subsection 2B.
2B. To be or not to be, one of the two. So if the door was opened this might be admissible. It sounds like it is. It depends on the finely, nuanced lettering of this rule. It was a recent fabrication. We're only counting the number of times that Mr. Tucker is told about the law.
Okay. The statement is not hearsay if the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement. And the statement is, subsection B, consistent with the declarant's testimony. It is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication.
I think it's allowed in.
I don't think this is recent fabrication because...
But it's motive.
Recent fabrication would mean that somehow or other he's being alleged to have, in the very, close to his testimony, fabricated, and then the advocate for that witness says, no, here's something that he said months ago that shows that this isn't recent fabrication. So it seems to me it's improper influence, that the Penny Phelps interview was played by the defendant to say that Penny Phelps fed you this narrative, to use the term that's been employed here, and you basically said, yeah, that's it, and it was her idea, not his idea. So, just the timing that I'm wondering about here. So the timing
has to be a recent fabrication.
The Phelps interview was in, when did we say? In
2017, Judge.
The testimony here is in 2024, and the statement that you want to admit is in 2022. So could you just explain the argument again, Mr. Mansfield?
Right, Judge. So now that he has attacked the veracity of his statement as having been coerced by Penny Phelps, well, he gave another statement almost 5 years later, and it's consistent with the testimony he gave this jury on direct examination. So again, if there was the Penny Phelps story, well, 5 years later, he gave a consistent version of those facts, identical to what he testified to this jury today.
But this is after the Penny
during
Phelps
this trial.
Okay, and so anything further from the defense?
Well, I believe you already admitted there's inconsistencies between the interview he gave with Penny Phelps and what he's given today. Why would that be any different in that statement?
I don't follow Tucker's reasoning there.
Not the inconsistencies. I believe the whole implication that the defense is wanting to say is it's basically the whole thing is a lie. That it's Penny Phelps' version of events that Johnson has just adopted as his own in so many words, and he's fine-tuned it a bit. Yes. But
Your Honor,
yes,
if
sir.
I may, the statements that he made, again, Penny Phelps' time, yes, we do believe that they were fed to him. However, he's had 6 years now to fine-tune those statements.
Right.
So, again, even all the, yes, he was there. He can draw a map. Yes, he's there. He could do all that. He could do everything that the state's saying. That's true, because he was there. That's very simple. And yes, because he was there, he can give all that information and probably keep it accurate. The part that's a problem is that Penny Phelps gives him the one key that he needed to get that deal. I'm the getaway driver.
Judge, he keeps arguing the very nature of why I want to move. He keeps arguing that Penny Phelps unduly influenced this defendant. And the rule allows for me to play a prior consistent statement that corroborates his version because the defendant has attacked it as being unduly influenced.
Your Honor, if I may, one other thing.
Yes, sir.
Okay, this prior and consistent statement, I mean, that would make sense if he had actually given that consistent statement prior to Penny Phelps.
There's a good argument.
I'm sorry, prior consistent statement prior to Penny Phelps. Then it would make sense.
That's a good argument. Saying the same thing after the Penny Phelps has told him what to say. No matter how many times he says it afterwards, he's already been told what to say, is what Tucker's saying there. And it's post.
Judge Jones?
Yes.
In the abundance of caution, because I don't want to create an appellate issue, I'm not going to move it in. I'm not going to seek to move it in.
His counsel's like, this might not be a good idea.
I think that's a wise choice.
He just withdrew it.
Right.
Judge likes this because he doesn't have to
It's
make a decision.
It's a close call. I mean, one way or the other, it's a close call.
I truly believe this is the kind of trial that you get one shot at, so I don't want to create that issue.
Fine. May I ask, do you have a witness standing by?
Yes, sir, we do. Two of them.
I'd like to do recross, Your Honor.
Well, I don't think that's going to happen, Mr. Tucker. You've had more than ample opportunity to cross-examine about everything multiple times, so we're not going to be having any recross, sir.
Okay.
That's not the norm to begin with. I made an exception, but anyway, I won't repeat myself.
Judge, I just have a brief follow-up, and I'm done with this witness, and we'll move on to, I don't even know what time.
All right, bring in the jury, please.
Mr. Mansfield, who did you tell me to call? Mr. Mansfield.
I'm sorry?
Was it the Emmy or Angela?
Whoever's sitting out there. One of the two.
One of the two.
Okay, the clerk is concerned if there's some exhibit that's in the machine that she doesn't have. She's very
He just won against two seasoned prosecutors.
Keeping track of everything, which is
that was impressive.
Desirable.
The fact that the prosecutors also said they're withdrawing it because they don't want appellate issues. They know that this is a dangerous ground. They're asking for an exception to a very hard and fast rule.
Thank you. Please be seated, everyone. Thank you for your patience. We've handled our business and back to the redirect of the defendant.
Thank you, Judge.
Witness, excuse me.
I'm sorry, sir. So picking back up, Mr. Johnson, so just to confirm, when you were approached in April of 22 about working with the state, you gave another sworn statement.
Correct.
And then you testified to the jury today.
Correct.
Were you consistent with that statement?
Yes.
Just 1 second, Judge. Judge, at this time, I have no further questions for this witness. Thank you, sir.
Yes, sir.
1 second. I guess we're going to need to approach the bench here.
Okay, so interesting stuff here. Is the defendant allowed to text a friend during a trial? The defendant has, I believe, standby counsel, but not sitting next to him. It's not immediately in his ear, counsel whispering, coaching him along. So I believe the defendant is allowed to text whoever he wants to during the trial, whether it's counsel or the news. I mean, he can do what he wants. I think it would be unwise to carry on conversations extracurricular to the case this time, but I think he can do whatever he wants there. I should have asked if he's actively in touch or how that goes. You know, he's representing himself, but he still does in some way have lawyers assisting him to some extent. Please recap the witness statement. They just tried and failed to move into evidence. Okay, so Mr. Tucker tried to impeach the witness, Travis, using the video that was taken when he was first admitted guilt. When Travis first admitted guilt at the police station. First he says, "You got the wrong guy. I don't know whose truck that is." Everything. Then when he's shown the videos, or told they have the videos, he admits to everything. Penny Phelps.
Now, you are subject to recall.
Subject to recall.
So my suggestion is that you maintain some contact with the state to get further details.
Understood, Judge.
Any other instructions anybody wants at this point?
No, sir. I just would, since he's still under potential recall, no talking about the case to anybody outside the courtroom.
Correct. Okay.
So Travis can head down to the beach. Just bring your phone with you. Anyway, so after this impeachment attempt,
state's next witness.
Yes, sir. We're going to call Dr. Michael Stecktower.
Dr. Michael Stecktower. I don't know. The state tried to use another recorded statement made after that first recorded statement that Tucker played as proof of prior consistent statement. And Mr. Tucker, on a couple attempts, on the third attempt, had a very good argument saying you can't say it's prior because it happened after. Happened after the recording I played. So at that point, the state withdrew their motion to submit this item O.
Sir, if you please step forward through the gate right there.
And said that in order to avoid appellate issues, we're going to withdraw this.
Right in front of the witness stand. You stop about right there. Turn, face this lady. Raise your right hand.
Do you solemnly swear or affirm that the testimony you will give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, thank you. Have a seat on the witness stand, please. Good afternoon, sir.
Afternoon. Judge, may I proceed?
Yes.
Dr. Stecktower, you all set up? Okay.
I am.
All right, good. Good afternoon, sir.
Good afternoon.
Dr. Stecktower, could you state your name for the jury?
Absolutely. I am Dr. Michael Robert Steckbauer.
And how are you employed?
I am the current District 16 medical examiner.
Here we have the ME.
Did I mispronounce your name just now? Okay, good. Dr. Steckbauer, you are employed as our medical examiner?
I am.
And how long have you been doing that work down here in Monroe County?
About 6.5 years.
Okay. This is the part where I ask you to take the jury back a little bit about the progression of your career to get you to where you're at today.
Yes.
Yes, sir.
So that long odyssey started many years back. I went to undergraduate. Well, actually, that's not really true. Initially, out of high school, I went into the military. Did an active duty stint in the Army for 6 years as a veterinary technician of all things. Thought I wanted to go to veterinary school. Clearly wanted to go to medical school. So then I went off to the University of Nevada, Las Vegas, and finished my bachelor's. I got a bachelor's in science with a minor in chemistry. Biology is the major, and minor was chemistry. I then went on to the University of Nevada School of Medicine to medical school, and I completed my medical degree. After that, I went off to my residency, which was in pathology, anatomic and clinical pathology. After completing that program at Ball Memorial Hospital in Muncie, Indiana, I did take what is called my anatomic pathology boards. This is essentially a test that one can take. You don't have to take it to practice, but if you take it, it shows that you have achieved a certain level of knowledge. So I did achieve board certification in anatomic pathology. I then attended my forensic pathology fellowship at the Miami-Dade Medical Examiner's Office. Upon completing that fellowship, I did also take my forensic boards and achieved board certification in forensic pathology. That entire time I was in the Army National Guard as well. I was a combat medic initially, and then later, upon completion of medical school, I went to the Army's Flight Surgeons course and have been practicing with the Army National Guard as a flight surgeon since. When I graduated that fellowship, I went off to Duval County, Jacksonville, as an associate medical examiner. I was there for about 2 years, and during which time I was deployed to Kosovo with the Army National Guard. I then went down to Broward County as an associate medical examiner in 2013. Was there for a number of years, ultimately becoming their director of medical education at one point, later becoming their deputy chief, and at the end of that being deployed to Kuwait and Iraq with the Army National Guard. After that, I then came down here and have been in this position since. During this time here, I also have a private practice. I do the forensic autopsies for the Royal Police in the Turks and Caicos Islands, almost all of their cases. I do the hardcore forensic cases for the Royal Police in Bermuda, as well as in the Cayman Islands, and do private autopsies. I think that covers everything.
Okay. So
very well covered.
You mentioned the phrase forensic pathologist, right?
Yes, yes, sir.
All right, let's tell the jury, what are the duties of a forensic pathologist?
Forensic pathology differs from general autopsy medicine, autopsy pathology, in that it specifically centers on medical legal death investigation. And really kind of to just be generally broad with that, it means we do autopsies that are legally mandated on things that would meet the classifications of manners of death of homicide, suicide, accident, so strange we just don't know what it is, undetermined. Now we do plenty of natural deaths as well in that work, but they're simply because there's no regular doctor to sign, or they don't know exactly what's going on, and so they're kind of questionable and they come to us. And so we do the background investigation into those cases. They come into the office. We do the autopsies on them, interpretation, follow-up interpretation of toxicology test results, and microscopic examination. Of course, we testify on those cases, such as I'm doing here today. We do education for law enforcement and fire, as well as a number of other people. We occasionally have medical students, residents, paramedic students rotating through the office. We do education with them. Occasionally we do outreach to different organizations, do training as well.
Doctor, you talked about autopsies. About how many autopsies have you performed in your career?
Well, I quit counting a number of years back. I'm probably roughly about 5,000 at the current moment.
And how many down here in Monroe County? Can you even estimate, or is that a rough one to get
we
to?
do about 150 a year here in this county, 6.5 years, so you can do the math on that. It's roughly about 900. But of course, as I said, during that time, I have continued to do the cases for the Royal Police in those different island nations. You add those on top of it, it's probably somewhere around roundabouts another 100 cases, including my private autopsies per year. And then I did, in fact, help out the chief medical examiner in Palm Beach for a number of years. I'm not really sure how many I did total for her, but if we say somewhere between an estimate of 250 to 300 per year.
Wow. Now, are you a member of any specific groups or specialized groups?
Yeah, most pathologists, and specifically forensic pathologists in the United States, will be members of the National Association of Medical Examiners. It's really our only major group. We do have another group, but they're very minor compared to NAME for membership. Almost all forensic pathologists in the state are members of NAME. And then I am a fellow of the American Society of Clinical Pathology as well.
Have you ever been published?
I have.
And when I say published, what are we talking about?
Most of the time when you're talking about published, you're talking about either case reviews or full clinical research.
And you have been published before?
Yes, absolutely.
Do you receive continuing education in your field, or is it you've already known it, so that's it?
No, there are no current residencies under the guidance of the American College of Graduate Medical Education that are allowed to not do continuing medical education. You have to. So I do continuing medical education. I do that both for my board certification as well as for my medical licensure. The state licensure board here in Florida requires 30 to 40 credits of CME per year. Some certain classes mandated, others you can do it in whatever area of medicine you'd like. And then the American Board of Pathology requires 70 credits themselves.
And do you have to do that to maintain your accreditation or your certificate to practice?
My certification. Now, there is, I guess, one other caveat to that. I was unluckily one of the last people in my year group period that still had to take a high stakes test at 10 years to renew my board certification. Thankfully, they got rid of that and they changed it in pattern, but I did actually about a year, and I think that was a year and a half ago, I took a large exam, 10-year exam within my field to show, in fact, that I did still know what I knew and that I had kept up on it.
Now, are you board certified by the American Board of Pathology?
Yes, that is correct.
Is that above and beyond your regular certification, or is that the one we're talking about?
That is the one we're talking about.
All right, fair enough. Now, let's talk, you already explained to the jury an autopsy. You said an autopsy can determine cause and manner of death. Is that right?
Yes, that is correct.
So let's talk about the difference. When you say cause of death, what are you referring to?
The cause of death is that thing that led to the physiologic derangement in the body that was no longer compatible with life. The manner of death is a category that the cause of deaths fall within. I like to use the example of things like a firearm death. You can have a firearm death that is in fact homicidal. Somebody pulled the trigger and caused that person's death. You can have a firearm death that is suicidal. Somebody pulled the trigger themselves. You can have a firearm death, although they're not common, you can have a firearm death that is going to be accidental. The firing pin or something is malfunctioning and the weapon gets jostled, goes off, and the projectile strikes somebody. In that case, that's an accidental death.
Now, during the autopsy, you do something called an external examination and an internal examination. Is that fair?
That is correct.
Let's talk about the differences. First, external examination. What, if anything, are you looking for when you conduct that?
An external examination is exactly what it sounds like. It examines the external surface of the body. Now, I do tell everyone, especially when I have police from the Academy for the initial training, I say that the autopsy begins with the scene investigation. Whether that's a scene investigation that I directly perform or a scene investigation that the law enforcement officers have performed and relayed to me. You know, you can have a person who dies, and without that information, you're kind of flying blind. You have a 30-year-old, you know, who's dead in their bed. That could be potential drug overdose, could be suicidal, homicidal, and that investigation that they're performing is helping you to kind of move along the pathway of what may have caused it and what sort of ancillary testing you're going to do. So then we get the body into the morgue, we do the intake, which is weighing the body, doing some photographs, and we examine the outside of the body. The general hair, state of the hair, color of the hair, length of the hair, if there's any findings in any of these things. The eyes, the general color of the eyes, if there's any findings in the eyes that would help to indicate to you what the cause of death was. If there's some yellowing, they could have hepatitis, things like this. The mouth, are there any findings in the mouth? 30-year-old who comes to you and has no other findings, and the teeth are in very bad repair, you're immediately going to be concerned about things like methamphetamine addiction. So the teeth can actually steer you in certain directions as well. You can find little linear lacerations that indicate a person was
this guy loves his job.
Punched in the lips, pressed against the teeth. You're then going to look at the outside of the body. Any marks, scars, identifying features, any tattoos, any injuries. Look at the genitalia. Are they normal? Are there any findings in the genitalia? And that roughly covers the external exam. Once you've finished the external exam and you've taken photography and documented it, you're going to move on to the internal examination of the body. Internal examination is exactly what it sounds like. You are going to open up the thoracic cavity and the abdomen, via what is called a Y incision. The tissues will be reflected back. We document all of this in place. If photographs need to be taken, we do take them of any pertinent findings. We examine the organs in situ, inside the body as they present themselves, and then we remove them. We weigh them and we dissect them further. We take toxicology specimens as we go. If available, we try to get vitreous fluid from the eyes. We try to get peripheral blood, meaning blood that is away from the heart, towards the common iliac vessels. We gather urine if it's available. We gather bile from the gallbladder because certain substances are in fact concentrated in bile. Once we've done all of that, we then reflect the scalp, open the calvarium, of course examine the brain in place, take it out, weigh it, dissect it as well. We do keep small sections of, representative sections of all of these organs and any specific pertinent findings as we go. And again, like I said, we take photographs as we move along this process if they are needed.
Now, Dr. Stegmaier, let's take you back to November of 2017. Were you conducting autopsies in Monroe County at that time?
I was.
All right. And were you asked to perform an autopsy on someone who came identified to you as Matthew Bonnet?
I was, and I did.
All right. And did you go to the scene on this particular death?
No, I did not.
Okay, sometimes you do go to the scene, right?
Absolutely.
All right, this one you didn't.
No, generally if the body has been transported from the scene, of course, I'm a forensic pathologist, not a crime scene investigator. My expertise is in that body, and so generally if the body has been transported to the hospital or otherwise, we do not attend the scene, and that was the case in this situation.
Okay. Now the identification of the body was Matthew Bonnet, is that right?
That is correct.
And you were asked to conduct an autopsy on Mr. Bonnet?
I was.
And do you recall when you conducted that autopsy?
Yes, the autopsy was conducted on the 21st of November at 10 a.m.
Is that at your office here in Monroe County?
Yes.
And were you alone or were you with someone when you conducted the autopsy?
Generally speaking, we almost always have a technician, and I would have had a technician on this case. I do believe at the time of this autopsy, Dr. Prasanna was present. There were a number of law enforcement officers who were present as well.
And
that must have been fun.
Okay, so you were asked to do the autopsy and you performed it, you said on the 21st, right?
That is correct.
Okay, so let's take the jury through the autopsy. First of all, can you describe Mr. Bonnet in general?
Absolutely. As per the report, the body is that of a 69-inch, 173-pound adult white male who appears consistent with the reported age of 59 years. The body was well preserved. It was cold. Rigor mortis was present. Livor mortis was present. It was posterior, red, purple, and fixed. His hair was of medium length and white in color. The eyes were brown. The surrounding sclera were not icteric. The conjunctiva were not congested and did not have any petechiae. His nasal bridge was midline. The oral mucosa and frenula were intact, means he didn't have any defects within the mouth. The teeth are natural and in relatively good condition, and the external canals were free of blood. His neck was generally straight. His chest and back were symmetric outside of the injuries and medical intervention that were present. His abdomen was flat. His external genitalia were those of a normal circumcised adult male. The testes were palpable in the scrotum. His external anus was unremarkable. His arms and legs were normally developed.
We're not getting any sound bites
from this. He did, in fact, arrive to my office with bags covering the hands. That is normal to do in cases in which it is believed that an altercation has occurred. It allows us to better process the hands and potentially take things like fingernail clippings, because DNA can be present underneath the fingernails from the person that they may have gotten in an altercation with. And so bags were present on his hands. They were removed by me, and I did, in fact, obtain fingernail clippings from Mr. Bonnet. There was a
Was he reading something, or his eyes closed?
Scar in the lower midline of his abdomen. He did also have what we call our senile ecchymoses that had minor superficial skin lacerations.
He's reading something.
These are kind of what people call old age bruises.
Anything on the external, any evidence of fatal injury on the external examination?
Yes, absolutely.
And what, if anything, did you observe?
So moving on to the evidence of injury section on the report, initially the first thing that we described was a stab wound of his left upper arm. And the report has some specific measurements, and it has measurements of the actual wound. It has some measurements that kind of orient it on the body, and how whether or not it has two sharp edges or just one. In this case, it had a single sharp edge at 9 o'clock. This helps us. It helps to indicate whether or not we have a single-edged weapon or potentially a weapon that has a serrated edge on the opposing side. And then it was described as having only gone down into the muscle and soft tissue about 2 inches. He also had another stab wound of his left upper arm.
You said that was in the upper arm, is that right?
That is correct. Left upper arm.
Left upper arm?
Yes.
Front, back, or side?
Specifically, that wound is 11.5 inches from the top of the head and 8 inches left of the midline. And so it is in the lateral aspect of that arm.
And would that wound have been fatal?
No, it would not.
And from the, I guess from the cut that was made on the body, I guess when inflicting that wound, can you give us any information on the knife that potentially was used based on that wound?
Well, again, as I stated a moment ago, it had a sharp edge that was at the 9 o'clock margin of the wound. And so that is indicative of a weapon that is not double-edged. Now, it doesn't mean that the weapon can't have a side that is serrated, but it does indicate that it is unlikely that it is a double-edged knife.
And that's for, as far as that wound, correct?
That is correct.
Okay. Now, there were other wounds, is that fair to say?
Absolutely. There was another stab wound within the left upper arm. It is also to the relative lateral, the outside aspect of the arm. It was T-shaped. It's a 4.3 by 1.5 centimeter stab wound. It was 14 inches from the top of the head and 11.5 inches left of the midline. That stab wound went down about 3 3/4 inches into the muscle and soft tissue of the left upper arm. So that's a decent distance. You think about that, 3 3/4 inches is right about there.
And again, that's in the upper left arm, near the other wound?
Near, yes.
Okay, and that was in the arm. Would that would have been fatal?
No.
Okay, let's go on to the next one.
The next wound is a stab wound of the mid-back. This wound specifically is a 3.2 by 0.5 centimeter stab wound. It is 18.5 inches from the top of the head and 1 inch left of the midline. And again, it is in the left side of the mid-back. It's oriented from 9 o'clock to 3 o'clock and reapproximates to 3.3 centimeters. These are just things we use when we describe the wounds. The path of the wound extends down into the posterior aspect, the back of the left side of the chest at the 10th and 11th ribs. It then goes into the thoracic cavity, and it goes through the left side of the diaphragm. It does not injure any other major structures. There is a liter of liquid and clotted blood that's collected within the abdominal cavity that is associated with that wound. That wound specifically has a directionality that is from left to right, front to back, and downwards.
And that was, you said that was the first wound in the mid-back, is that right?
That is correct.
All right. And would that wound have been potentially fatal?
It could have been fatal if, in fact, no care was rendered. It did not injure any large major structures, but by going into the back and going through the diaphragm, it absolutely would have caused a pneumothorax, and no medical attention would have meant that he would have passed away.
Now, was there another wound in the back as well?
Absolutely. There are 2 combined wounds in the mid-back, and they are described exactly as that, 2 stab wounds in the mid-back that form a general L shape. And the first is given some description, same as these other wounds that we talked about, the measurements of it, 3.5 by 0.6 centimeter stab wound that is 14.5 inches from the top of the head and 2 1/4 inches left of the midline. In the left side of the mid-back, it's oriented from 7 o'clock to 1 o'clock and reapproximates to 3.7 centimeters. The second wound that connects with this, making that L shape, is 2.8 by 0.5 centimeters. It's 15 inches from the top of the head and 2.5 inches left of the midline in the mid-back. It's oriented from 9 o'clock to 3:30 and reapproximates to 2.8 centimeters. So then in the report, what I did with this, because these wounds do what we call commingle, they combine, I described it as such. I said, please note that due to commingling of the wound tracks of these 2 stab wounds, they are described together. The path of the wound extends down. It enters the posterior aspect, the back of the left side of the thoracic cavity, the chest, at the 7th and 8th intercostal space. The wound tract, the injures the descending aorta at the level of the 9th thoracic vertebra, and the left lower lung lobe is also perforated. Associated with that wound is a liter of liquid and clotted blood in the left side of the thoracic cavity. And the path of that wound is from back to front, left to right, and downwards.
Now, you did say you photographed during the autopsy, is that correct?
I did.
All right. Judge, have you already shown defense counsel was marked as Quebec? Composite with 4 photos in it, may I approach the witness?
Yes.
Marked as Quebec. Q. Just know that we may see some images from autopsy that might be alarming. These are professional photos of an autopsy that might document injuries on the body, so just be aware.
Are those photographs consistent with the person that you performed the autopsy on?
Yes.
And some of them are actually from the autopsy, is that accurate?
Yes, all but one are from the actual autopsy.
Judge, at this time I seek to move into Quebec.
Any objection?
The prosecutor just proposed moving to Canada.
Exhibit Q for identification is now admitted into evidence.
Oh, sorry, I thought he said he wanted to move to Quebec.
Exhibit A through D.
All right, Dr. Stegmaier, so now that it's in evidence as state 16, composite, judge may I publish to the jury?
Yes.
First, I'm going to show the jury the first photo, and that's Dr. Stegmaier, what are they seeing here?
This is a photo that law enforcement frequently sends us. We ask for something for an identifying image of the decedent when they first call us. If they have a driver's license, they send us a driver's license. If not, they will send us a copy of their screen, the computer screen. We always call it a David photo.
So does this help you in the identification process?
It does. It helps them in the identification process.
Now, let's talk about the wounds that you just testified to. I'm going to show them this one next, Dr. Stegmaier, just so you understand. And then if you could just tell the jury what they're going to see in this photograph, or these 2 photographs.
So what you're seeing in this, these 2 photographs is you're seeing one of our standard photographs of the lower half of the back of the decedent. But you're also seeing one of our other standard photographs of the upper half of the back of the decedent. And in that upper half, you can see that there are 2 injuries of the back. You don't see them as well because this is a general overall photo. Those photos are taken much closer as well.
Trying to
Does the back kind of elucidate where those stab wounds were that you were testifying to?
They're intentionally
It does.
blurred. There's no detail you can see.
And the one looks almost like a V or something, is that the one that you talked about having combined?
Yes,
The combination of two stab wounds?
absolutely.
So, and then there's another one down here, is that right?
Correct.
All right, so let's talk about this one here. This is going to be D in the composite?
Yes.
Okay. If you want to narrate it while I show the jury.
Sure. So this is exactly what I was talking about. We did, in fact, do a close-up photo of those injuries with what is called an L ruler. It's a legal ruler. But there is also another photo there. This is as the tissue has been reflected away. That photo is actually of the injury from one of the stab wounds of the arm. It's showing that it goes into the deltoid muscle.
That's this one over here.
Yes, that is correct.
So one's a real up close and personal look at the arm injury, and the other one is a closer look on the two back stabs.
Correct.
Am I saying that accurately?
Yes.
If any of these pictures are highly inappropriate, I'm going to try to float my
Were you ever
disclaimer over
provided
the
with
top
a
of them.
weapon in this case to examine?
I was.
Here's what the jury's going to see in this one.
So these
I'm sorry, this is for the record, this is 16B.
These photographs, the top one is actually just a standard image we take. It is what we call a face shot. These are often used for identification by family members and others because they can be cleaned up on a computer surface. The bottom one is a picture of the knife that was presented to us at autopsy as potentially being the weapon that was used.
And what was the purpose of presenting you with the knife?
The primary reason that they presented me with the knife is that there is a laceration, abrasion, impression along the nose that is quite consistent with the butt of that knife. They wanted to compare those two. We do, in fact, have an autopsy photograph where that knife is held adjacent to the decedent's nose, comparing the back of that knife to the impression along his nose.
Were you able to opine at all whether that knife would be consistent with the stab wounds that you discovered on Mr. Bonnet?
Yes, it is.
It is consistent?
It is.
Okay, and can you give the jury, like, how do you go about that examination of the knife to the wounds?
Whenever you're professionally trying to evaluate and say, could this be consistent with or not, you're looking at things like what we talked about earlier. Is the wound single-edged? Is it double-edged? Is the weapon single-edged? Is it double-edged? Things like this. If we have injuries that could have been caused by another part of the weapon, are there patterns to those injuries that would go along with some part of that weapon? In this case, of course, we do. And so when you evaluate those things together, it makes the instrument, the weapon, consistent with the injuries that you're seeing.
Dr. Stecker, I'm going to show you what's in evidence now. It states 14. And have you take a look. Do you recognize it?
Yes, it is the knife that was presented to me at the autopsy.
All right, and take a look at the blade of the knife. Is it that two different sides, or is it all consistent?
It does, in fact, have two different sides. One has a normal sharp edge, and the other has what we call a serrated edge.
Now, the stab wounds in the back, is it consistent? Are those injuries consistent with having been caused by this knife?
Yes.
And what about the ones in the arm?
Yes.
And then you said the butt of the knife also caused a nose injury?
It is consistent with the injury on the nose.
Okay. Can I have that picture?
We'll see you, Vicki. Have a good night. Thanks for being here.
Dr. Stecker, I'm going to show you a summary in evidence in state 6. You recognize the photo?
I do.
Is that Mr. Bonnet?
It is.
Now you see a nose injury there, right?
Yes.
Is that the nose injury you're talking about?
It is.
And you said it's consistent with having been caused by the butt of the knife?
It is. This photograph does not depict the pattern well. There is another photograph that depicts it much better.
Just telling the prosecutor you chose the wrong photo to show it.
Thank you. Did you do a toxicology on this person?
Yes, we did.
And when I say a toxicology, what exactly am I talking about?
It means that we did, in fact, obtain the specimens that we spoke about earlier. We did, in fact, obtain blood from the iliac vessel. We did obtain urine, bile, and vitreous fluid, and we did send those off to the University of Florida Toxicology Lab in Gainesville for testing.
And did you receive those results?
We did.
And what, if anything, did that test reveal as far as what was in Mr. Bonnet's system?
So the test revealed that his blood was, in fact, positive for ethanol, alcohol, at 140 milligrams per deciliter, or 0.14 grams per deciliter. And they do that conversion because it helps people to understand it. When you say 0.14, you can compare that to your reference range of 0.08 being the legal limit for driving while intoxicated. And so it kind of gives you just a general reference, and that's why they do that. The blood was also positive for cocaine at 301 nanograms per milliliter. This is important because cocaine is one of the fastest metabolizing drugs in humans. Almost all parent cocaine will have been metabolized to its metabolites within about 15 to 25 minutes. So having parent cocaine is significant, and that means that that cocaine would usually have been taken within the last 15 to 25 minutes. Otherwise, we would only have metabolite. We also have coca-ethylene, which was positive at 421 nanograms per milliliter. This is important because it lets you know that there has been some metabolism time between the alcohol and the cocaine. Those two combine together and create the metabolite coca-ethylene. Benzolecithnine was also positive in the blood. That is the primary metabolite, active metabolite of cocaine. It was present at a level of 1,958 nanograms per milliliter. And then when we look at...
Let me ask you a quick follow-up question. On the cocaine, were you able to, by the levels of these various breakdowns, I'm not going to try to pronounce them, but are you able to tell how recently he had used cocaine prior to his stabbing?
Right. So just to correct myself, it's 1,968 grams. Should have used my glasses, clearly. Just want to make sure I said not 1,958, it's 68. And yes, as I was describing earlier, we can say that at least the cocaine itself was used within roughly 15 to 25 minutes of his death, because again, we had parent cocaine in the blood.
And that's indicative from the coca-ethylene?
From the cocaine itself, because
from
again,
the cocaine itself.
Cocaine metabolizes relatively quickly, and so if you have parent cocaine in the blood, that means that cocaine was ingested or used within the last 15 to 25 minutes. The metabolites could in fact be due to the ingestion or use of the cocaine that we're seeing that's still in the blood, or they could be metabolites that are partially due to prior use as well. I cannot say that.
So the parent cocaine, the fact that it's in the system, would give you that time estimate of the last 15 to 20 minutes because it metabolizes rather quickly.
Correct.
All right, let's go on to the presence of any cannabinoids.
Okay, so
I was asking about marijuana.
Yeah, might as well.
See that?
There are cannabinoids present in the urine as well. They're positive. It is important to understand that urine indicates past use. Urine does not indicate current use. Blood indicates current use. And there were no cannabinoids identified within the blood. They were only identified within the urine, which again means past use.
Past use not present at the time when he was stabbed.
Correct.
So he'd fail a drug test, a P test,
right, so
but
then
he was not high.
Anything else
as far as marijuana goes?
Of evidentiary value from the toxicology report?
Well, there are, I mean, it just depends on the questions that would be asked. The urine was also positive for ethanol at 185 milligrams per deciliter, and the vitreous humor, the fluid from the eyes, was positive at 140 milligrams per deciliter. Now, it is important, oftentimes we look at blood versus vitreous fluid for different drug levels to say whether they're still in the absorptive phase or metabolic phase. In this case, they're equal. Both were 140, so that means that he's kind of at a steady state.
Of alcohol consumption.
Of alcohol, correct. And the urine was also positive for those other metabolites in active parent cocaine that we talked about, the cocaethylene and the benzoyl 9.
Now you had said, so in all, he had cocaine and alcohol in his system. Is that fair to say?
In their metabolites, correct.
And you had mentioned his hands had been bagged, right, for preservation?
Correct.
Did you submit fingernail clippings?
I did, in fact, turn them over to law enforcement.
Okay.
Law enforcement then submits those fingernail clippings.
Did you provide them to law enforcement for further testing?
I did.
And did you also provide a DNA card for Mr. Bonnet for further testing?
I did.
Now, Dr. Steckbauer, when all is said and done, did you make any findings to a degree of medical certainty as to the cause of death here?
Yes. In this case, the cause of death was stated as multiple sharp force injuries and the manner of death as homicide.
Now, how are you able to determine it was multiple sharp force injuries and not cocaine overdose?
Well, again, the one injury, well, the two combined injuries that we spoke about.
The one that formed the V in the back?
Right. They, in fact, did injure the aorta, and they, in fact, did cause a good amount of blood to collect within the thoracic cavity. That is not compatible with life. It also had the injury that went through the diaphragm and up into the thoracic cavity and the blood within the abdomen. Those are not compatible with life. Although any amount of cocaine can cause a person's death, clearly the sharp force injuries were much more, I don't want to say impressive.
Dominant?
They would have a much greater effect.
So the fact that the stab wound in the back punctured or perforated the aorta, is that a fairly significant wound?
Yes, the aorta is the largest blood vessel in the body. It's under high pressure, which is why that blood collects within those cavities. The blood that would have been lost is, of course, probably even greater than that which we quantitated, because blood is going to have come out of those wounds. On top of that, you had emergency personnel who, in fact, were trying to save his life. They did a thoracotomy procedure in which they did open the chest in a way that we call a clamshell, which literally means they make a large incision, they open it up. They're trying to get access to repair those injuries emergently so that they can stabilize the person. And so some of the blood would have been lost then as well. So it's almost a certainty that he had lost more blood than what we're talking about in the report.
So emergency
Now,
services,
did you
they
issue a
opened his
death
chest?
certificate in Matthew Bonnet's name in this case?
I did.
And on the death certificate, do you put in the information about cause and manner of death?
I did.
Was there, Dr. Steckbauer, I'm curious, was there any evidence on his body, Mr. Bonnet's body, of a struggle? Was there bruising on his arms or legs or knuckles, anything that would be evidence consistent with a struggle?
Well, he does have some additional injuries, and depending on how you would categorize those injuries, some of them could be indicative of a struggle. He had some bruising of the knees, if I remember correctly. For some reason. Oh, that's why. So specifically, he had a laceration. It was surrounding purple bruising of the bridge of the nose. We talked about that. He had a red abrasion, linear red abrasion of the bridge of the nose. He had an abrasion of the right cheek. He did have a healing wound of the right knee. Now, that's not indicative of an altercation at the current time because, of course, it's healing. But he did, in fact, have a purple-brown bruise of the right knee, which could be indicative of an altercation. He also had a brown bruise in the right foot, which could have been part of this altercation. He had a healing wound of the left knee. Again, it's healing, so it's old. He had a red abrasion of the left side of the upper aspect of the chest, which could have been a part of this altercation. He did also have a superficial red abrasion of the left upper extremity, again, could have been a part of this altercation. And he had a laceration in the left upper extremity, which could have been a part of this altercation.
So many of those would be consistent with some kind of a struggle or a fight at the time of his stabbing?
Yes.
Judge, if I just may have 1 second.
Yes.
Yes, you may have a second. I've been working on the thumbnail.
Nothing further for Dr. Stegmaier, sir. Thank you for your time today.
Let's see what cross comes here. Oh, I think he's going to focus on the left hand,
We're
right?
going to take a little break before we have cross-examination. We've been in a session here for a couple hours, so bear with us. It's going to be a 15-minute break. Members of the jury, you don't have to stay in the jury room. It's follow the usual procedures. 3:21, that would put us to 3:36. So see you back here. Continue the testimony.
So I think the best thing Mr. Tucker could do right here would be to possibly, I mean, I'm not his lawyer or his advice, so, but I imagine he's going to try to get some testimony out about the whole left-handed injury. Let's see, once the jury's out of the room, if they have any more. Anything else going on?
All right, our jurors have exited the courtroom. You can take a break also, Doctor. Just remember, we have the rule of sequestration of witnesses, so you're not to discuss your testimony with anyone during the break. Any other instructions? No? All right, we'll be back.
Okay, they're going to take a break. Judge is first one out of the courtroom. He's leading the charge, so to speak. So we'll leave them right there. We're going to jump over to our thumbnail because I've made a couple additions. So if you'll give me just a minute, let's see what we've got. What have we added? Let me turn off the... Let that off. Why is it not working? Come on, come on. Downstream keyer. It's not liking me at all. My Law 101 does not want to go away. There we go. Fixed it. All right, so we've added a couple things. All of them are over here by the Treehouse, so we don't have to worry about the side on the truck. You can see I moved the tarp to be on the wall down here, so more down on the ground level, because we know that, so the little tarp pieces, we still have the tarp on the roof. We might keep that. The flag, though, is back, and you can see I've got a little reference to Detroit now flying on the flag. We do have, let's see, a couple of things. We've got the Starbucks. We've got the Coconut Telegraph. We've got Eeyore down here. And, what happened over here? Let's see. Oop, we have smiling poop emoji. We have some doo-doo, because we've had at least 4 doo-doo references by this witness. So we've had a little bit of additions here. All right, I think that's all we have so far. I don't know if there's anything else that I can reasonably add. There were a couple suggestions that might be quite difficult, but let me know if there's something else. Nosy Rosie, you're not asking again. Well, I am not watching chat, so unless you're asking someone else, you might have to ask again because I'm missing it. Let me scroll back. I'm not seeing it. Did he add Tom Thumb to the thumbnail? No, because Tom Thumb is like a book, right? It's a book about a little tiny little guy who fits in your hand. We could add just a thumb. But Tom Thumb, we need a thumb with a B. A thumb. Let's see. This is a nice one. This is a nice one. Maybe if we, where would this go? Let's experiment a little bit. Let's shrink it down quite a bit and put it behind something. I'm going to send this back a layer. Realize we're not trying to mock the trial with this. We're just trying to understand all the different components and things that have been introduced in the trial. So when we look at this, we can see exactly what has been discussed in the trial. That's where we are. All right, Tom Thumb's a grocery store. Yeah, but how do we represent the grocery store in here? That's our dilemma, Tracy. I appreciate that. There's a grocery store that plays a major role in this. So that's our latest and greatest. We have a thumb. It's like a hitchhiker thumb. No to the thumb, says Barbara. It's a storyboard. It's like a story. Is there a crack in pipe? The crack is right over here. You can find crack right here on the way up to the treehouse. That's how you get to crack. Right, Tom on the thumb. I have not. Well, the only thing I've written on is the crime scene and the late notes. I'm not a big fan of writing on things to identify them. If they're not obviously apparent as to what they are, I don't want to write too much on them. A thumb with Tom on it. Just noticed the late. That's hilarious. Knows he wanted dandelions. All right. The one that we timed her out for asking for weed. All right. That's why she's not asking again. Okay, hang on one second. Weed. Ooh. Well, it knew exactly what we were asking. I don't see the dandelions yet. Let's see. A little bit of sticky icky. Let's see. Weeds. Maybe if we say weeds, it might. Aha. Here we go. I don't know. Maybe we just do a little weed. Is there a... Do we have a plant? One like this, maybe? Just growing. Where would it grow? Do we have a flower pot somewhere? I think it should grow out of a flower pot. Bing, here's our flower pot. We're going to just do a little work here to get it everything in proper perspective. Let's see, this is pre-harvest, clearly. Let's see, this needs to be back one layer. Send backwards there. Now our plant's growing out of the pot. It's pre-harvest. It's early. I mean, this is a youngling, I think. We're going to group those two together, and now we'll resize them down. Just a little pot. Where are we going to put our little pot? Sitting on the chair, is that? Let's see if we can get it smaller. In the window? Maybe in the back window. Let's put it right in there. And then, of course, we need to make it a little less clear, so it's because it's through glass, right? There we go. Okay. Is that happy? We've got some weeds. Now we have some weeds in the picture. All right. All right. I don't think there was any pot in the truck. The pot was, everyone says they smoked in the trailer or in the tree house. I think that's where it's going to stay right there. I'm happy with where it's at right now. All right. It's just cluttered in there. Hey, Mary, there's a lot of stuff in this case. There's a lot of evidence. There's a lot of things that we have to weigh. And when we snowflakes. Does everyone understand the reference here if we talk about snow? Need a pile of snow. Snow or blow or something like that. Let's see. Snow. it's just we can make it snow over the entire scene. Now on our still shot, this won't work. But let's see, make it a little bigger right up there. It's snowing. Is that this does not look like Key West? That's my problem. Look up chalk. Okay, let's delete the snow and let's go with different powders. Hang on, I need to make sure we're not missing anything. We're not. Okay, we're good. All right, full screen powder, like baby powder. Oh, that's powder. That's powder. You have to say white powder. How specific do you think? Ooh, that's not bad. It's not bad. I mean, it's... Let's see, what else do we have? I mean, you got a spoon and everything. I mean, how much? Let's see what we can do with this one. Where would the powder be? On the boat, maybe? On the ship with the Captain Morgan? Let's take a look. This is going to be very small, okay, because the tin was small. Oops. That was bad. That was bad. What did I click on? Stop. Whatever I did, stop doing it. Go back to where we were. Okay. Let's get rid of this picture. We need it smaller. It's going to be small. Don't worry. It's going to get small. We're going to set it down about right here. We're going to put it down to about right there. And now we're sending it back a layer. Back another layer. There we go. Now it's sort of on the boat. Supposed to be in front of that. There was white powder on the boat. That's why it sunk. I'd like that to stay pretty subtle. Is that subtle enough? What's the pirate for again? That's Captain Morgan. Can you not see Captain Morgan? It's Captain Morgan's foot ups on the chest and everything. Just a 1-star like flake on the palm tree. Let's see. We're going to bring this one right up here. We're going to make it white. And make it really small. Okay. So it looks like this. Is that all right? Little snow up there. It's actually in a bad spot. Probably up here. It needs to be right there. There we go. Okay, little snow. You have your snow. I think we've now documented everything so far. Put an 8-ball. No. We don't. We're not going to do a treasure chest of snow. That's not it. We want something on here to reference all the items that have been suggested in the trial. So as we watch the thumbnail, we can recall the evidence or the testimony that's been given by different individuals. I think this is going to be a trend going forward with each trial is build your own thumbnail. Where's Molly? Molly was... Did they say they smoked Molly? I thought Molly was more of an ingestion type drug. No, I'm thinking like Britney Spears club drug. I didn't realize it was something you smoked. Of course, I've never been on the scene, so I'm not sure. Oh, we need to key the truck. It's the wrong truck. Honestly, I think we need to take the defendant out of the truck because we've never seen him in there. There's no feng shui. the balance is completely off. The right is quite heavily weighted, and the left is just very light. So we got a foot locker. We did have a foot locker, and we have a knife. I haven't seen pictures of the foot locker in any of the evidence yet that has been presented. Let's see, a foot locker. Is that one word or two? I thought of it as like a, let's see all the graphics. That's locking toolbox. Okay, truck bed box, truck box. Is that what it is? He said it was a truck toolbox, right? That he used. Let's see. I'm thinking something like diamond plated. Is that what you have in mind? A diamond plated, toolbox that drops into the bed? Okay. There's our diamond plating, but where's the box? I'm not seeing anything that really strikes me as something that would work for this. Let me go back to court. Oops, sorry. Turned the lights off on you guys. Okay, we're still good in court. We'll have to work on the foot locker. All right. With that being said, let's see. They smoke it to go to quicker buzz. That's the Molly. Isn't it a pill? Is Molly a pill, or is it a powder? Is it one of those pills that you sort of build your own pills? You put the powder in the pill and then ingest it. Burger King, we've got to be careful with logos, corporate logos. We can't put corporate logos in there. I'm worried about the Red Wing logo, the Detroit. Let's see. Add truck to your search. Sand toys for Travis. I'm not sure what Travis does at the beach. That's the thing. I'm not sure if he's just like a sun bunny where he just soaks it up. Where's CVS? How would we put CVS on here without? Well, I know where CVS would go. I can tell you that CVS is going to go right. If we do it, it's going to go right here underneath the. We could do a pharmacy. You guys, I'm with you. I see what you're talking about. There's a pharmacy. Whoa. Okay, we're back. We'll have to focus on that later. We're back in court. I'll work on the pharmacy angle. Good thing the jurors weren't there. We would have just showed them.
I see him. You'd please come on back up to the witness stand, Doctor. Okay, welcome back. The jurors brought in. You're still under oath.
No, thank you for asking.
Everybody's here who should be. Bring in the jury, please. Thank you. Please be seated, everyone. Welcome back to the courtroom, members of the jury. We have the witness back on the witness stand, remain under oath. So let's.
I'm done with the witness. Before I sat down, I wanted to move into evidence which was previously marked as Romeo. It's the death certificate.
Is there any objection?
No.
All right. Admit number 17 for the state. All right. So now cross-examination.
Forgot to say good afternoon when I came in. I was such of a rush. Good, welcome back. Dr. Sackbauer, I'm going to make this real quick, real painless, I think. I would hope. Now, in your report, you stated that the knife is consistent with the wounds and it is most likely what killed Matthew Bonnet, correct?
Consistent with.
Consistent with it. Okay, so not exactly, it's not 100% sure, but it is consistent, correct?
Correct.
Okay, good. Same thing with the was it the injury on the bridge of the nose?
Yes, correct.
And now you said you do DNA spot cards. We did a depo with you, I believe, and I was reading something about your DNA spot cards. Could you please explain what that is?
Oh, absolutely. So we do in this office, we do a DNA spot card on all of the autopsies or even external examinations we do. We obtain blood from the decedent and we make what we call spot card. These are just little cards. They have little circles. You've probably seen them on Hollywood. We do actually use professional spot cards, which means we purchase ones. The paper is impregnated with certain substances to help stabilize the DNA for testing, and then we make them and we retain them. The majority of those spot cards never actually get tested. They're just retained in the file.
Okay, so they're retained by the medical examiner's
by my
office?
office.
Okay.
Yes, sir.
Okay. And again, when I was reading our deposition of you, you were made aware of the DNA results. Is that correct?
To be honest, I don't recollect.
I would imagine not. It was quite a while ago. Now, without going into the DNA results, one of the other things I happened to notice in our deposition of you, if two different blood types, two different samples of blood are found on the same blade, what is that indicative of?
If two
different
blood
separate
types.
Samples, yeah, two different.
Not two different DNA patterns, just two different blood types.
Yeah, two different. I guess even two different DNA patterns. If you find multiple sets of blood, I guess on the same blade, it would be a better way. I'm a layman, so you gotta excuse my lack of medical knowledge here. But if you found two different types of blood on the blade, what would that be indicative of?
It would indicate that there were two contributors.
Two contributors.
Two people.
Okay, and which would mean that blade was probably used on both people, correct?
It would just mean that substance containing two people's DNA was on the knife or whatever object was tested. It wouldn't necessarily mean that it was used on two people because, of course, you cast DNA simply from your palm, but of course it could have been used on two people too. I don't know.
I think I understand what you're saying here.
I'm sorry, Mr. Toker. Would you mind moving the podium here
sure
a little
can.
bit because I'm having a
sorry.
hard time seeing the state's table, and I do need to be able to see everyone. Thank you.
Thank you. Now, it wouldn't be 100% conclusive, is what you're trying to say, I think.
Well, I wouldn't say that. The fact that you would get a profile, and I would leave that to an expert in DNA to talk about the likelihood that a given DNA profile belongs to a given individual. Statistically, I would definitely leave that alone. But I wouldn't say that having a profile on a weapon means that that person had to be involved in using the weapon or not using the weapon. I wouldn't testify that. I would simply state that if I was made aware of it, that their profile was found on the weapon.
Okay.
I don't know if that answers
I think
the
you
question.
I think, again, layman here, I think you were talking about DNA transfer from other things too, it's possibility or, that kind of thing.
Judge, I'm going to object the question.
Oh, yeah, let me try and rephrase. Like I said, I'm trying to key in on medical terms that I'm not exactly familiar with. Okay. Again, we're going back to the DNA or the blood of different people being found on the object, whatever the object would be. Would that be consistent with that object being, again, coming into contact with both of those people?
Yes, absolutely.
Okay. I think that's a better way. I should have said it. Now, again, that would mean it most likely would be contact, though, not secondary contact like we were just talking. Like I was just trying to describe secondary. Like, okay.
I definitely wouldn't testify. It's okay. I wouldn't testify to that.
Right.
The likelihood. I would definitely defer to an expert in DNA.
Okay,
absolutely.
Good. Okay, and but you didn't test the knife, correct?
I did not. No.
Okay. And again, I think let me check here because I don't think there's too much else we need to go into. Now, just to clarify, when we were discussing all the wound patterns and the paths that you were talking about. Now, that doesn't say, again, it doesn't tell you much about the assailant, does it? The type of assailant?
No, not at all.
Okay, so it can't tell you how big, how tall, whether the right or left-handed, any of that?
No, it cannot.
Okay. So it doesn't tell you much about the assailant other than this is consistent, this weapon is consistent with the wounds?
Correct.
Okay. All right, and let's see. Oh, and I don't think you'll remember this. I don't know if you would remember during the deposition, I don't know if you saw the other victim in the case, Miss Paula Belmont. They showed you laceration. They showed you a neck wound.
Well, I'll listen to the question, but...
let me try and get to a question that's a little bit quicker and easier here. Were you shown pictures of the victim, the other victim, Paula Belmont, when you were doing the
I don't recollect.
I had a feeling a long time ago. Okay, and I'll tell you, there's not much else I think we need to go in with you, Doctor. Thank you for your time. I think we've addressed everything that we need to, so you can be excused.
Right.
I'm done with my cross.
All right, thank you. Is there any redirect?
Yes, Dr. Stepfire. The knife that I showed you, the one with the red and black handle, the one that's in evidence.
Yes.
Is that consistent with having inflicted the wounds in Matthew Bonnet's back?
It is.
Now that knife has a serrated side and a straight edge or a smooth side, right?
A sharp edge and a serrated edge, yes.
Sharp edge on one side, serrated edge on the other. And is that reflected in the wounds that you see in his back?
Yes.
So I guess one side of that wound has a serrated pattern and the other side has a smooth cut?
Well, the real primary thing is that you have a single sharp edge. Serrated wounds, serrated weapons can make specific patterned wounds. These wounds did not have a specific pattern that is directly associated with the serrated edge, just with not having two sharp edges.
Okay, so ultimately though, that knife that is in evidence you said is consistent with having inflicted the wounds in Matthew Bonnet?
It is.
Okay. I don't have anything else for you, Dr. Stegmaier. Thank you, sir.
Thank you.
All right, then. Thank you, sir. You can step down and be excused.
Thank you, Your Honor.
Okay, so nothing for Mr. Tucker on that one beneficial from the ME. Don't think there was a lot there.
State prepared to call their next witness.
Yes, Your Honor. State will call Angel Ozlowski.
May we sidebar for just a second, Your Honor?
Excuse me?
May we sidebar for just a second?
Okay.
Quick sidebar. While they're doing that, I'm working on the thumbnail. All right. Did prosecutor just move the podium? Maybe he wants the defendant to get yelled at against again. Yes, he does. They keep moving it back and forth. It's one of the most commonly moved pieces of furniture in the courtroom. You can't testify the knife for sure did it. He can only testify the knife like that one makes the same wounds as the one found. Yeah, so it's like he's testifying that these wounds could have been made with this weapon. He's not testifying that this is the weapon that made the wounds. Speaking of weapon wounds, I actually went to the hardware store down the road and was talking to them and said, I looked in their knife. They have one of those little glass, behind locked cabinets where they sell knives. And there's a knife that I'm looking at buying for demonstration purposes for during the BK trial because it is the exact same knife. It's the same model. It's a USMC sheath. It's everything. It's $159 for the knife. I'm like, can I just rent it from you? Can I just rent it? Because I just need it for a YouTube video, and then I'll be back.
Please come forward, ma'am. Could you approach the deputy there? Stop. Face the clerk. Raise your right hand.
Do you solemnly swear or affirm that the testimony you will give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Is this our...
The witness stand. Speak loudly and clearly.
The judge mumbles, speak loudly and clearly. Is this our DNA expert?
Permission to proceed, Your Honor.
Yes.
Good afternoon.
Good afternoon.
Please state your name and spell your last name for the record.
Angela Oslowski, Oslowski.
And where are you currently employed, ma'am?
With the Florida Department of Law Enforcement in the Fort Myers Regional Operations Center.
How long have you been still employed in that capacity?
Since January of 2016.
Okay, and what is your position with the Florida Department of Law Enforcement?
I'm a crime laboratory analyst in the biology section.
I wouldn't want to sell a weapon to anybody.
Your educational background.
So I have a Bachelor's of Science in Biochemistry Forensic Science from Suffolk University in Boston, Massachusetts. And I have a Master's of Science in Forensic DNA and Serology from the University of Florida.
DNA lady. Here we go.
What are your duties as a crime laboratory analyst in the biology section at Florida Department of Law Enforcement?
So as a crime laboratory analyst in the biology section, I analyze items of evidence for the possible presence of biological material, collect samples for DNA analysis, interpret my results, write reports, and testify in court as needed.
What, if any, specialized training do you have for your position as a crime laboratory analyst?
So with the Florida Department of Law Enforcement, I underwent a two-part training program in which first I learned about the serological processes or the testing for biological material. I took written, oral, and practical examinations and then did supervised casework under a qualified analyst. And then the second part of my training was for the DNA analysis process. And I also did written, oral, and practical examinations, and then the supervised casework under a qualified analyst for that portion as well.
Okay. And as a crime laboratory analyst for FDLE, do you have an occasion to perform DNA testing?
Yes, I do.
And approximately how many times have you performed DNA testing in your career as an analyst for FDLE?
FDLE instead of FLED. Not
I would
FLED.
say it's at least been over 5,000 samples.
Okay. So over 5,000 samples?
Yes.
And how long have you been performing DNA testing?
So since November of 2017 when I completed my training.
In addition to your background training, do you undergo any proficiency testing?
Yes, I do.
Please explain to the jury what type of proficiency testing you undergo.
So twice a year, I will get samples from an outside laboratory in which they know what results are expected from the samples that I'll be working. I work them as if they're regular casework samples. I'll obtain results and report my results to them, and this will test my ability to do my job as well as the DNA analysis system.
Have you ever been qualified as an expert in DNA testing?
Yes, through the Florida Department of Law Enforcement.
And have you previously testified in court as an expert in DNA testing?
Yes, I have.
Approximately how many times?
Approximately 25 times.
Okay. Judge, at this time, I would ask the court to recognize Ms. Oslowski as an expert in the area of DNA testing and analysis.
Any objection?
No, Your Honor.
Recognize the witness in that area of expertise.
Thank you, Your Honor. Ms. Oslowski, please explain in layman's terms as best as you can, what is DNA?
So DNA stands for deoxyribonucleic acid. It's the basic building block of all human beings. You get half of your DNA from your mother and half of your DNA from your father, and it's essentially what gives you your height, eye color, hair color, things of that nature. Greater than 99% of your DNA will be the same among each person, and less than 1% is what varies among each person, other than identical twins, which will have the exact same DNA types.
Were you asked to perform DNA testing in this case?
Yes, I was.
Please explain for the jury what type of, or what method of DNA testing you utilized in this case.
So I test for something called short tandem repeats, which are actually short segments of DNA that each person has, but what varies is how often these short segments repeat. So for example, since I get one type from my mother and one type from my father, at one location I might have 11 repeats and 12 repeats, and then another person might have 9 and 10. And I actually test 21 of these different locations.
Okay, and what method of what are the steps used in short tandem repeat DNA analysis?
So there are 4 steps. So first, I will either collect a sample from an item of evidence or take a cutting from an item of evidence, and this will get heat and chemicals, and this helps break open the cells so I have access to the DNA within it, and it also helps clean up the sample. Next, the sample will go through something called quantitation, in which we'll see how much DNA is actually present already in the sample. Then the sample will go through something called amplification, in which those 21 short tandem repeat locations will be amplified millions of times. And this way, during capillary electrophoresis, which is essentially a part of the process that separates the DNA out by size, so that way I can then look at it on a graphical type of form, so I can interpret the DNA results.
Thank you. And as an analyst, what procedures do you take to assure the quality of the testing?
So when looking at items of evidence, I ensure that I use a face mask, hairnet, lab coat, disposable gloves, and then every area and utensils are cleaned with something called cavicide that will remove DNA. And then during each step of the process, something called controls are used to ensure that each step of the process is working correctly.
Please explain for the members of the jury, what are controls?
So controls are there'll usually be a positive and a negative control. So a positive control will contain something that I'm expecting to get a result from, and it'll get the chemicals or whatever part of the process that I'm utilizing, and it'll get all of those elements. And I'll expect to get a result from that, and that shows that everything or all the reagents in that step of the process was working correctly. And then the negative control will still get all the reagents, but nothing else in it. So that way I would expect to just still get absolutely no results obtained for that, just to show that nothing extra was added in at any point.
Is the laboratory where you conduct your testing at, is it accredited?
Yes, it is.
Okay, from who?
From the American National Standards Institute of National Accreditation Board.
And for the jury's knowledge, what does that mean?
So that means that my laboratory is following a set of certain high standards that are set forth in the forensic and scientific community.
Once you finish your DNA analysis process, what types of results can you obtain from your procedures?
So after doing that 4-step process, I can get something called a single source profile, in which I have DNA at all 21 locations, where I would say it's a complete single source profile. So that indicates that I got information at all 21 of those locations, and it's indicative of one individual. I can also get a mixed DNA profile, in which I have DNA results that indicate there's more than one individual that's present. I can also get DNA results that are too limited to interpret, which means that I had some information that was obtained, but because of its limited nature, it's not enough to say how many individuals are present and to do any comparisons to. I can also get DNA results that are too complex, in which there are more than 4 donors present, and therefore I really truly can't say how many individuals are in the sample, and therefore I cannot interpret that as well. And then I can also sometimes get a mixed DNA profile, but there's one clear high donor, and the information for the additional contributor is very limited. And so I can call that profile, I'll say it's a major DNA profile that was obtained, and I can do comparisons to that high profile that's present.
Okay, and what are your results used for?
So the results from the evidence samples are used to then compare to standards or known samples of DNA collected from individuals.
Explain for the jury what are standards.
So a standard is usually collected as a buccal swab, which is a swab directly from an individual's inside cheek or buccal cells, or it can also be blood stain card or blood. And this is to represent, so it'll go through that 4-step of the DNA analysis process in order to get a DNA profile to represent that person's DNA.
Okay, and did you receive standards in this case?
Yes, I did.
Would you please explain or tell the jury what standards you utilized in this case?
Is it okay if I refer to my notes just for
yes,
the...
Yes, it'll refresh your
names?
recollection, Your Honor.
I'm going to go out on a limb here and say she's done this before.
I obtained buccal swabs from Franklin Tucker, buccal swabs from Rory Wilson, excuse me, buccal swabs from John Johnson. I also obtained a blood stain card from a Matthew Bonnet, as well as buccal swabs from a Paula Belmonte. And then I believe I also got buccal swabs represented as being from a Roger Raggett.
Roger.
And did you do the testing and compare those buccal swabs compared with other items of evidence that you were requested to do so in this case?
Yes. So for each of those samples, it went through that 4-step of the DNA analysis process, and I was able to get complete DNA results from all of those standards to represent individuals, and then comparisons were made to question samples in this case.
Okay, now, talking about the results, what are possible results as a result of your testing? Is there things that, for instance, explain to the jury what does inconclusive mean to you?
So inconclusive, so when I'm doing a comparison to a DNA profile from a questioned item of evidence, in which I have results that are comparable or interpretable, I then do a comparison to a standard, and sometimes when that comparison is done, the result is it's inconclusive. And this essentially means that I cannot say for certain if that individual is included or excluded as a possible contributor to the mixed DNA profile. So when I'm doing comparisons, I do something that's called a likelihood ratio, which is essentially comparing one event under 2 separate situations. So it's usually the DNA results given if a person contributed their DNA versus another person in the population with those DNA types. So when I'm doing that comparison, if it falls in that inconclusive zone, it'll be a range in which during my validation, it showed that there were some false inclusions and false exclusions when compared to standards. So in that range, I truly cannot say if that person is included as a possible contributor or excluded as a possible contributor.
Okay. Based on your training, experience, your expertise in the area, would there be instances where there is no DNA, or there is not sufficient DNA for you to come to a determination?
Yes. Sometimes with items of evidence, as I said, the DNA might just be too limited, so I can't do any comparisons to it, or other times even with a mixed DNA profile, there might be information for a contributor or one of the individuals that makes up that mixed DNA profile that is higher and easily comparable to, and then sometimes there might be a second or third donor that's a little bit more limited in nature and has less DNA types present. And a lot of times that's where the inconclusive comparison will be seen.
For instance, is there necessary automatic DNA on this pen because I'm holding it in my hand?
Not all the time. So DNA, it depends on a lot of different factors that can contribute to DNA being left behind. So it depends on the individual. Some individuals shed their DNA more easily than other individuals. And then on the item, it depends on length of contact. So the longer one holds onto an item, the more likely I'm expecting to see DNA present. If someone touches an item very briefly, it's less likely to see that DNA present. Also, depending on the item, the DNA that's possibly already on that item, as well as the item itself. If it's a smooth item, less DNA usually gets left behind versus a rough item, because rough surfaces will kind of slough off more DNA. So it really depends on many factors.
Okay. if a person had gloves on, would that affect the DNA analysis?
Yes, that can affect leaving DNA behind.
And it would mean it would be less likely that DNA would be left or present on a particular item of evidence that you were asked to examine, correct?
Yes, that's possible.
Judge, may I have a moment?
Yes.
So how about the prosecutor just gets up there, swears in, sits on the witness stand, and just says what he wants us to know, because he's leading like crazy with every single witness, even the expert who is fully capable of giving the proper answer.
Kozlowski, I think you said Mr. Tucker was one of the standards that you received in this case, correct?
Correct.
And there were inconclusive items that you could not include him in with respect to certain pieces of evidence. Is that fair to say?
Some of the items that I did do comparisons to his standard were inconclusive, and I could not say whether he was included or excluded as a possible contributor to those items.
Nothing further from this witness, Your Honor. Thank you.
Okay.
That was it. It was all background and no results. Can't see he's included or excluded.
Agent Oslowski, I don't know.
I'm just crime laboratory analyst Oslowski.
Okay.
Or analyst Oslowski is fine.
Did you get the subpoena that I tried to send?
I don't think so.
Okay, just checking.
Did you get my subpoena?
I had the wrong email. Whatever. Okay, so we just heard the prosecutor go over the explanation for inconclusive results. Now, did you get some conclusive results in this case?
So there was some DNA evidence that I compared the buccal swabs, and he was excluded as a possible contributor to those DNA profiles.
Okay, and would that DNA profile include the knife that was tested in this case?
Is it okay if I refer to the notes for all those
please.
samples?
This witness is
so
able
I
to-
did take a sample from the blunt end of the handle of the knife, and for that, Franklin Tucker was excluded as a possible was inconclusive. So he failed to demonstrate sufficient statistical support for inclusion or exclusion to that item. For the handle of the knife that I took a sample from, Franklin Tucker was excluded as a contributor to that mixed DNA profile.
This is huge. Tell us what
I believe those were
what was on it. Who was on it?
the main samples that I took from the item, other than I did take 2 areas from the blade in which I got a complete DNA profile, but that DNA profile had matched the DNA profile from Matthew Bonnet.
And was that a mixed DNA profile as well? Was there somebody else on that blade?
So on area C and D of the blade that I had taken, that was a complete profile. So that was indicative of a single source profile. For the handle of the knife, that demonstrated the presence of a mixture consistent with 3 donors.
Okay, and who were those 3 donors?
Good.
So I did comparisons to standards that were submitted in the case. Rory Wilson was included as a possible contributor to the mixed DNA profile, and then I did the likelihood ratio that I mentioned, which is a statistic to do to give weight to that comparison. And the observed mixed DNA profile is 12,000 times more likely to occur if the sample originated from Rory Wilson and 2 unrelated individuals than from 3 unrelated individuals. I then did a comparison to Matthew Bonnet. He was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is 9.9 million times more likely to occur if the sample originated from Matthew Bonnet and 2 unrelated individuals than from 3 unrelated individuals. I did the comparison as well to Paula Belmonte, and she was included as a possible contributor to the mixed DNA profile. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte and 2 unrelated individuals than from 3 unrelated individuals. And then I also did a comparison to John Johnson, and he was excluded as a contributor to the mixed DNA profile.
Okay, and Ms. Oslowski, just in layman's terms, because I love the science behind it, but I'm a little bit more of a layman. Would that mean that it's highly likely that Rory Roy Wilson at some time handled that knife and that it came into contact with both Matthew Bonnet and Miss Paula Belmont?
So since I'm never present, I can never fully say how DNA got on an item, when it got there, or under what circumstances. I can only do the comparison and say if the DNA types could be included as a possible contributor to the mixed sample, and then do a likelihood ratio to that comparison.
Okay. But again, those are the three main contributors I would from what I'm gathering from your report.
Those three individuals were included as possible contributors, and then I did the likelihood ratio to get the statistic for it.
Okay, and what about the mask that you tested, the mask that was used?
So for the mask, let me take a look. So I took several areas, several samples from the mask. So an area A of the mask that I called, which was a area that gave chemical indications for the presence of blood. And this was on the exterior bottom right jaw area. The DNA results was a complete DNA profile consistent with a female individual. And that DNA profile matched the DNA profile from Paula Belmonte. And I did a statistic, or the likelihood ratio, to that comparison, and the observed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte than from an unrelated individual.
I'll translate that.
And there was other limited data that was not interpretable that was observed in that sample, but was too limited to do any comparisons to. So that was one area. Then there was another area that gave chemical indications for the presence of blood. I named this area B, and it was on the exterior right side of the forehead. And the DNA results obtained from that area demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And then I did comparisons to all the standards that were submitted. Paula Belmonte was included as a possible contributor. I did the likelihood ratio. The observed mixed DNA profile is greater than 700 billion times more likely to occur. The sample originated from Paula Belmonte and 1 unrelated individual, then from 2 unrelated individuals. And then comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate sufficient statistical support for inclusion or inclusion, so therefore it was in that inconclusive zone, so there's no determination can be made regarding the contribution of Franklin Tucker. And then Rory Wilson, John Johnson, and Matthew Bonnet were excluded as contributors to that mixed DNA profile. I then had an area that I called Area C, and this was also an area that gave chemical indications for the presence of blood. And this was the exterior left bottom jaw. The DNA results obtained demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. Matthew Bonnet was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Matthew Bonnet and 1 unrelated individual than from 2 unrelated individuals. And then Paula Belmonte was included as a possible contributor to that mixed DNA profile. The observed mixed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte and 1 unrelated individual than from 2 unrelated individuals. I then compared to Franklin Tucker, Rory Wilson, and John Johnson, and they were excluded as possible contributors to that mixed DNA profile. I then took a sample from the whole interior of the mask, and that demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And I did comparisons to the standards that were submitted, and Rory Wilson was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Rory Wilson than from 1 unrelated individual than from 2 unrelated individuals.
Times is
Comparison of the profile from Paula Belmonte to the mixture obtained failed to demonstrate the sufficient statistical support, so it was in that inconclusive range. And therefore no determination could be made regarding the contribution of Paula Belmonte to that item or to that area. And then Franklin Tucker, John Johnson, and Matthew Bonnet were excluded as contributors to that mixed DNA profile.
Ms. Oslowski, again, just if I put it wrong, just please correct me. Now, Area A, C, B, the jury's not quite, I'm sure, we're not looking at the same map right here. Would it be proper to say that Rory Wilson's DNA was the high contributor on the inside of the mask?
She's not going to say it the way he wants it to. She's going to put it statistically.
So for the inside of the mask, he was included as a possible contributor, and then I was able to do a likelihood ratio to that. And then otherwise, Franklin Tucker, John Johnson, and Matthew Bonnet were excluded as contributors, and Paula Belmonte was failed to demonstrate the sufficient statistical support for inclusion or exclusion.
What was the likelihood of Rory Wilson?
So the observed mixed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Rory Wilson and one unrelated individual than from two unrelated individuals.
Okay. And then the rest of the ones the rest of the samples that you had were from the outside of the mask, is that correct?
Correct.
Okay, so that would have been a contributing of Paula Belmont and Matthew Bonnet, correct? They were conclusive.
So these were areas that were reddish brown in color and gave chemical indication for the presence of blood. And then for area A, it was a complete female, consistent with a complete female individual, and it matched the DNA profile of Paula Belmonte. And then I did the statistic, the likelihood ratio. And then the area B was a mixture consistent with two donors, and Paula Belmonte was included as a possible contributor. And then for area 8C, which was a mixture of two donors, Matthew Bonnet was included as a possible contributor, and Paula Belmonte was included as a possible contributor.
Okay, thank you. Now, as far as the inconclusive results, there's a lot of things that can cause inconclusive results. Is that correct?
Correct.
Okay, and again, I've heard of secondary DNA transfer. Can you please explain what that might be?
So secondary DNA transfer is something that would occur. So say that I touch this glass of water, and then the bailiff touched the glass of water, and then we swabbed his hands, and my DNA was on his hands. So we didn't have any direct contact, so it was secondary transfer.
Okay, but that's where that likelihood ratio comes in. Isn't that correct? Where it's more direct, or there's more than enough DNA for the sample?
So honestly, with my DNA results, I can never say how the DNA results got there. I can't say if it got there from primary, secondary transfer. I can only testify to the DNA results that I obtained and then do a comparison.
Would it be more likely if there was more of a sample, say if you had a larger sample as opposed to a smaller one?
It really depends on the sample. And depending on the item. So sometimes it might be a really large item, but there just might not be DNA present. So sometimes DNA just isn't present on an item. Other times there could be DNA results, but it could just be too limited. Or there might be DNA results if there's a biological fluid, and sometimes that DNA result will be more prevalent than other DNA that's present.
Now, the prosecutor also mentioned gloves, how that might affect the DNA results. Now, would gloves totally block the DNA, or would it be the DNA that's on the outside of the gloves that you might pick up, in your opinion?
So wearing gloves, I would expect DNA to not go through the gloves. I wear gloves at my job when I'm doing DNA analysis to try and prevent my DNA getting on an item. But obviously it's difficult to say what DNA might be on the outside of the gloves depending on if an individual touched other things and then touched something else. So it would be difficult to really say.
Right, that would be that secondary DNA transfer would be outside of the gloves, right?
Depending on what they touch or if they touch the outside of the gloves themselves.
Okay. Okay, so again, we go back to those inconclusive results. They can happen for a lot of reasons, and could you explain some of the reasons that might actually happen?
I'm sorry, one more time, did you say?
The inconclusive results.
And Selena K from Gifted Memberships.
So with the results where I cannot say definitively if they're included or excluded, so obviously it's possible that the DNA just, when doing a comparison to an individual, their DNA might just not be present. And obviously that can be an option, as well as sometimes, as I was saying, there can be DNA that's present, but it could be too limited or not enough to be able to see the DNA types there. And sometimes there can be another high profile that could be overwhelming the sample, preventing other DNA from being present. So those are kind of the three main things that can affect seeing DNA present.
Okay. Again, like if a mixture like that, it becomes hard.
Ask the question.
Hard and that, I get it.
Is there any test aside from my buccal swab?
Was there
that conclusively identified me
any
anywhere?
DNA from Miss Bellamont on any other objects besides the mask and the knife that you tested?
Just gonna look through.
So there were a couple areas where he was excluded.
So
like
I
the
did
blade of the
have
knife.
some clothing that was submitted. There was a dark blue long sleeve shirt. And I tested some areas and took some samples forward for DNA analysis. So there was the inside left wrist that I took a sample from, and that demonstrated the presence of a mixture that was consistent with 2 donors, including at least 1 male contributor. And Paula Belmonte was included as a possible contributor to that mixed DNA profile. The observed mixed DNA profile was greater than 700 billion times were likely to occur if the sample originated from Paula Belmonte and 1 unrelated individual, then from 2 unrelated individuals. I also obtained partial DNA profiles consistent with a female individual from the inside back left forearm as well as the inside front left forearm. And those DNA profiles matched the DNA profile of Paula Belmonte. And the observed DNA profiles were greater than 700 billion times were likely to occur if the samples originated from Paula Belmonte than from an unrelated individual.
Micah, you need a pro. Get someone with more experience. He needs that question. Was my DNA found anywhere? Aside from my buccal swab, or buccal swab as she's been saying it. Buccal swab. Buccal. B swab. Aside from my swab, did you find my DNA anywhere?
And then I also had a shirt, another shirt that was from a Roger Roggett. And I had a sample from, let me see. So with items that are collected directly from an individual, I can expect to see their DNA types present. So this item was said to come directly from Roger Roggett. So I was expecting to see his types, and there were 2 areas, the back middle right and back lower right, and he was expected to be a donor to that item. And then a complete foreign DNA profile consistent with a female donor was obtained from items 17D and 17E, which was the back middle right and back lower right. And that foreign DNA profile matched the DNA profile from Paula Belmonte. And then I did the statistic, and the observed foreign DNA profiles greater than 700 billion times were likely to occur if the samples originated from Paula Belmonte than from an unrelated individual.
Okay, and Ms. Oswalski, I'm just going to ask you a few more questions just to make sure here. Now, was my DNA, Franklin Tyrone Tucker, just to be clear, was my DNA included in anything in this case? Was it actually, included as nothing inconclusive?
So for the DNA results that I obtained, there was no samples that he was included as a possible contributor.
Boom, mic drop, sit down, you're done.
One other thing, the reason I asked about secondary DNA transfer, how often does that happen airborne? Does it normally have to be something you touch or something you come into contact with?
I'm sorry, can you ask the question one more time?
Can you have airborne DNA transfer, or is it secondary DNA transfer or anything like that?
It's difficult to say. I mean, if someone spits kind of on an item, then that can contribute to DNA being left behind.
I would imagine that could happen. Okay, so if you have something like the knife, right, and you have both victims' DNA on the blade or on that knife, right, now could it be concluded that it's highly likely it was used or came into contact with both people?
So once again, my likelihood ratio or my DNA testing doesn't determine that. I can't determine how that DNA got there. I can tell you that the samples that I took from the blade gave chemical indications for the presence of blood, and then tell you the results I got and then the comparison to the standards that I obtained.
No, but would it be highly unlikely that the DNA from one individual could go across the room to another?
Mr. Tucker's testifying.
I'm asking a question.
Well, yeah, but it seems like, but go ahead, finish the question.
Anyway, would it be highly unlikely that the DNA from one item could jump across the room and get on the wall?
Just cause speculation.
She's an expert. Boom. Yes.
Experts don't get to speculate, but if you are able to answer it, you may.
Witnesses don't get to speculate.
DNA cannot just move from one item to another.
That's what I was
across
asking.
the room.
Thank you, Ms. Oskowski.
Okay.
That's exactly what I was asking. Maybe I didn't ask you correctly, but thank you for your time, and thank you for coming out today.
Witnesses don't get to speculate, says the judge.
Is there any redirect?
Absolutely.
Absolutely. Bring out those gloves.
Good afternoon again.
Beat those gloves to death.
Good afternoon.
Start over with, you indicated or you testified and mentioned the name John Johnson.
Yes.
Was he excluded from DNA on the knife based on your report, if I refresh your recollection?
Double check. So from the blunt end of the handle, he was the comparison of John Johnson to the mixture obtained failed to demonstrate the sufficient statistical support for inclusion or exclusion for the blunt end of the handle, and then John Johnson was excluded to the DNA results from the handle of the knife, and then the two areas on the blade, as I mentioned, that that matched the DNA profile of Matthew Bonnet.
Okay. Just to recap for the jury, would you please recap for them the items of evidence that the defendant in this case could not be excluded from? They came up inconclusive.
Please go over the list of things that you have no evidence that proves.
So for the blunt end of the handle
anything.
of the knife, the comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate the sufficient statistical support for inclusion or exclusion, so I cannot make any determination to that item or that part of the handle of the knife. Were you asking just about the knife or just all items?
No, and the other items that were inconclusive with respect to this defendant.
Okay, so then area B of the mask that gave chemical indications for the presence of blood, which was the exterior right side of the forehead. The comparison of the profile from Franklin Tucker to that item failed to demonstrate the sufficient statistical support for inclusion or exclusion. And then there was the interior of the mask. Oh, no, excuse me. Let me see. Nope, not that one. He was excluded to the interior of the mask.
He was excluded from where his skin would touch the mask. Without no gloves, he was excluded from that part.
To the inside left wrist of the first shirt, the dark blue long sleeve shirt that I mentioned. Comparison of the profile from Franklin Tucker to the mixture obtained from item 11C, which is what I call it, the inside left wrist. It failed to demonstrate sufficient statistical support for inclusion or exclusion to that item. And then I also took a sample from the inside right arm, right wrist, left upper arm, lower back, and lower front of that shirt, and comparison of the profile from Franklin Tucker to that mixture obtained, because it actually demonstrated the presence of a mixture with 3 donors. It failed to demonstrate sufficient statistical support for inclusion or exclusion, so no determination could be made regarding the contribution of Franklin Tucker to that item. There was also a pair of black gloves, and from the right hand outside top wrist, I took a sample, and that demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And the comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate sufficient statistical support for inclusion or exclusion, so no determination could be made regarding that item.
Butler bailiff
Then
is sneaking a
from
drink.
the left hand inside of a glove, comparison of the profile, well, that first demonstrated the presence of a mixture consistent with 3 donors, including at least 1 male contributor. and a comparison of the profile from Franklin Tucker to that mixture obtained failed to demonstrate sufficient statistical support for inclusion or exclusion. So no determination can be made regarding the contribution of Franklin Tucker to that item.
That's the inside of the gloves. No DNA on the inside of the gloves where he would be touching. This is bizarre now. This is crazy. I hope Tucker moves for a directed verdict as soon as the state rests.
And I believe that concludes the inconclusive comparisons.
So it's safe to say that there was numerous items of evidence that you didn't have a sufficient DNA sample to compare with Mr. Tucker in this case.
So those are the items that I did get DNA results, but the comparison showed that it was in an inconclusive range. So therefore, no determination can be made regarding if he's included or excluded as a possible contributor to those DNA results.
Okay, and just to make sure you only received one mask to analyze in this case, correct?
Correct.
No scarves, no gator scarves or anything like that were ever submitted to the lab, correct?
Correct.
You testified with respect to, I guess, the level of DNA on the knife with respect to Mr. Wilson. What was that level?
Do you mean the amount of DNA that was actually present?
Yes.
Okay,
So John Johnson, is that also Travis? Who's Mr. Wilson?
Or do you mean the statistic? I don't know
getting
if I got.
lost.
Statistic, I'm sorry.
Okay, I was going to say, I don't think I
apologize.
got into the amount of DNA. So from the handle of the knife,
Yes, ma'am.
so that demonstrated the presence of a mixture consistent with 3 donors, and he was Rory Wilson was included as a possible contributor. And the observed mixed DNA profile was 12,000 times more likely to occur if the sample originated from Rory Wilson and 2 unrelated individuals than if from 3 unrelated individuals.
Okay. Now, Ms. Oslowski, if the defendant in this case is alleged to have been wearing gloves at the time of the murder and the robbery in this case, the likelihood that you would get an inconclusive result is a possibility, correct?
It could be possible. I do know gloves, as I said, can prevent sometimes DNA being left behind. But as I said, I can never fully say how DNA got there, when DNA got there. I can only just testify to the results that I obtained.
Thank you for your time. Appreciate it.
May I recross to ask a couple
You'll
of
have to
questions?
approach the bench here to tell me what the questions would be. If the state would like to join us.
Yeah, I've got a question, Judge. Since when are expert witnesses who've been certified expert in the court not allowed to speculate? Mr. Mark Jones, Your Honor. That was the second, I think, very bad call by the judge in this case. The first one was when Mr. Tucker objected to leading by the prosecution as they were leading their witness on redirect. And the judge said, nope, they're allowed to do it on cross. And he allowed it. And it's not cross. And even worse, the officers of the court, those 2 attorneys who have a duty to make sure if they know that something incorrect is presented in court to correct it, they said nothing. They said nothing and continued to lead. Oh, man. This is... Let's see if he gets to cross here.
Recross.
Brief.
Soslowski. Sorry to keep you up. I just need I just wanted to ask 2 quick questions. Do you know how long it was from the time that the crime occurred to when you got the first samples of DNA? The date.
So the offense date was listed as November 17th, 2017. And then I began working some of the items in this case August 14th, 2018.
So we're talking...
And then, let's see, so my report for the first submission of items was released in December 7th, 2018. I don't know if that's easier, maybe.
It's approximately a year. Is that it?
Approximately, yes. And that was all the standards, and the knife, and the mask. And then I had an additional submission of items, and that include the dark blue long sleeve shirt and the gloves that I had mentioned. And that was submitted September 18th of 2019, and then my report was released on March 31st, 2020. I then got another submission of items. The items were submitted on March 18th, 2020 and April 30th, 2020. And my report was June 25th of 2020, and that was the shirt from Roger Rauget. And the buckle swabs represented as being from Roger Rauget as well.
And just one more time, one more question here is, okay, inconclusive means exactly that, right? Can't be excluded, included. It means exactly that, right?
Correct.
Okay, thank you. Oh, and please enjoy your afternoon.
Please enjoy your afternoon.
No further questions for the witness, Your Honor. She's excused.
Okay.
So am I released from it?
Yes, ma'am.
Okay.
Released from subpoena, even the one you did not get via email. Okay, is the state done? It's Thursday at 4:37. They've got about 20 minutes left of trial time today. Is the state done with all their witnesses?
All right, members of the jury, we're getting near the end of our day here, but I do need to ask you to go in the jury room for a few minutes. I'd like to discuss a few things with the attorneys, and that way I can give you some very clear direction for the future. So please go in the jury room for a few.
Try to turn the volume up on the judge. He's a little soft-spoken. Listen, I didn't need physical evidence, but where physical evidence was collected, I needed him to be on it.
So what's on the state's agenda?
Judge, I think we're ready to rest.
You think you're ready to rest, or you're officially resting, or you need a little time to...
We are officially resting.
Move for a directed verdict right now.
Right. So then, what does the defense want to do at this particular time?
Well, Your Honor, we'll go ahead and let's see. Tomorrow's Friday.
I move for a directed
verdict. See if I can get Ms. Paul Belmont. Assuming we are going to file a motion for acquittal, but assuming that doesn't get it.
File a motion. I mean that.
I assume it doesn't get approved, but if it doesn't.
Well, I mean that would be something that I would be dealing with first thing in the morning. It's.
But could we do it in the afternoon?
No, that's not. No, that's not. No, I mean I can.
I'm not sure. I'm just not sure. I'm not sure of the process, Your Honor. I'm sorry.
Well, ordinarily. It is a motion that's made verbally without any kind of written motion. It's ordinarily something that is anticipated, and it's ordinarily a function of familiarity with the case, and so it's not. So it wouldn't be something that I would say we're going to put the jury off for. The afternoon when it's something we can deal with in the morning, and I don't see any unfairness to expect if you're going to make such a motion again. It doesn't have to be in writing. You can certainly gather your thoughts and have plenty of time between now and then to do it.
So he's allowing him.
That would be fine, Your Honor. The only thing is, at that point, we'll go ahead and I plan on calling Ms. Belmont.
Okay, so has all the groundwork been laid for that? Because that I assume it's going to be by the Zoom, and I assume that the setup in the, I assume she's still in the hospital. I don't know that.
She is still in the hospital,
And whatever equipment she needs on that end, and whatever address that she needs to hook up here, and whatever additional preparation you've made through our technical team. As always, the devil's in the detail.
Your Honor, the only detail that I don't have control over is the state. They wanted one of their investigators to be present. Ms. Belmont did actually have a request from the state, if they would want to hear it, that she's worked with a few of the investigators at the state attorney's office before. She was comfortable with, I think it was Frank
Zamora
and Tom Walker. She's comfortable with either one of them. I would ask that the state maybe take that into consideration.
So
we'll have one of them. We'll have one of our investigators at the hospital tomorrow morning, Judge. Is she at Lower Keys Medical?
She's Lower Keys Medical.
Can we see if Carrie's still here? I don't know that he is or he isn't. But
and did Your Honor get the letter from her physician?
No, I didn't. But I'm not questioning that that the Zoom is all right.
No, it's okay. I was curious because I know she said it was sent in.
Okay, I haven't received, my judicial assistant has not provided any kind of email or fax or otherwise U.S. mail.
Telegraph.
I know last time it ended up at the state
Express
attorney's
letter.
office. I'll have to see if that's where it got sent.
But that's not going to be a hang-up for me at this point.
I wasn't able to get in touch with him in his office, Judge.
Okay. So, I'm just concerned that logistically, I don't know.
None of us have been provided with a Zoom link yet. I don't know if that's going to be done tonight. I assume that Your Honor will get a Zoom link and we'll sign in the courtroom, I guess, and have her. We'll be here with the defendant asking questions. She'll be appearing on Zoom. We'll have our investigator over there. It's not my witness. That's all. That's what I'm expecting. And I haven't seen a Zoom link yet. So.
Well, and Your Honor, again, we weren't sure if we were going to end today or end tomorrow. We weren't sure about that. So that, again, it was based on when the prosecution was ended in its case. The only thing I would ask is that for the number or the email of the tech here in the court so that I can arrange it with them.
Let me ask you this. How long would you anticipate her testimony to be?
I actually don't anticipate it to be that long, Your Honor. Again, I don't know what they're going to do on cross, but I mean, her story is fairly simple.
Can you remind me, she testified during the Wilson trial. In what form was that?
So that was the perpetuated deposition testimony, and it was a video. I don't know, pretty long video actually, and then the cross-examination obviously was on the video and the redirect, so that was all done through that perpetuated testimony at the Wilson trial.
But it was also for 3 attorneys on the tape, so you guys probably narrowed it down to just the stuff you needed for that trial, correct?
Okay, I understand we can't predict the future. What I'm trying to do is the best I can understand what to reasonably expect tomorrow, because what if Ms. Belmonte is 2 hours? Are there other witnesses and things you have standing by? Or?
I do have other witnesses, Your Honor. I've been trying to get in contact with them to tell them, because I actually originally had them slated to run earlier. We've gone a little bit longer, so I've been trying to get in contact with them to make sure that they know that they're supposed to be on deck.
Okay, so I think if we try to put Ms. Belmonte on tomorrow morning, we could run into problems. I don't know, if our tech fellow, I would think he'd be available, if not, certainly one of our other members, but is everything going to go smoothly? Or is it better to, as much as I hate to say this, deal with the JOA motion, deal with the technical stuff regarding any issues about the Zoom, and have the jurors come at 1 o'clock, so presumably at that point in time, everything's in place for that presentation?
Judge, I think that's probably, I'm with you, it's unappealing, but I think I see where Your Honor's thinking. We're going to have the jury sitting waiting for us in the morning while we work all this out.
Yeah.
And I would rather not have that.
Yeah, I'm just, again, trying to be cautious and considerate of those folks. So we come in and I find out our main guy isn't here. We get someone else. Well, what kind of Zoom address? How's that equipment working? Have we tested it?
I would agree, Your Honor.
It's just better to have that cushion.
Understood, Judge. Just so Your Honor's aware, Judge, as far as the Zoom link, because I have the Zoom application on my phone. If Mr. Tucker or his representatives have that link or that application, they simply send the state an invitation. We can log on here via the court's internet system and join that meeting, but there are certain steps that need to be taken on Mr. Tucker's part at the hospital to get that in the way.
Well, I like your knowledge and your
Your Honor, I've discovered Zoom. It is on my phone.
It just, in my experience, things go wrong. Stuff happens. So
technology.
What I say is, I'm going to tell the jurors, come back at 1 o'clock. I'm going to tell us to be here at 9. I'm going to hear Mr. Tucker's motion for judgment acquittal. I'm going to then see if we can, whatever logistics, whatever coordination needs to be done to be sure that the testimony of Ms. Belmonte is as smooth as possible in terms of the presentation, the communication, and then if you can have someone else available after her, fine. Other than that, I guess you'll have the weekend to line up whatever else you anticipate, but we can deal with that tomorrow. So that's the plan. Anybody have any questions?
No, Your Honor.
No, Your Honor. Thank you.
Oh, my goodness.
Oh, that's a good question. Are you going to rest in front of the jury?
Better.
We will go ahead and do that right now, sir.
All right. Very good.
Is he? He's facing with second-degree murder, right? Or is it? Can somebody refresh my memory as far as the actual charge, the homicide charge that he's facing? First, second, third.
Thank you. Welcome back. Please be seated, everyone. All right, welcome back. Mr. Mansfield, on behalf of the state of Florida.
Yes, Judge. At this time, the state of Florida rests its case. We've presented everything we intend to present.
All right, members of the jury.
Well, I
the
get to
state
see the
has
jury's
now
faces
rested
right
its
now.
case in chief. So that's a point in the trial where the judge has to conduct some proceedings outside of your presence. Again, this is normal. That's the way trials go. You can see what time it is, so it seems to me that it's a good time to excuse you until 1 p.m. tomorrow. We'll take care of what we need to take care of, which is not short. And when you come here tomorrow, the defendant will have an opportunity to present evidence in his case. Once again, I want to reassure you that we're on schedule. We're big picture. We're on schedule, and so we all thank you for your flexibility, your attention, your patience, your understanding, and your participation as jurors in this case. Remember, follow the cautionary instructions. See you tomorrow at 1.
Okay, I wanted to tell you when the DNA expert was up there. She has the ability not only to to speak and say big words and numbers and know what they mean, but she has the unique ability to take words that have 3 syllables and condense them to words that have 1 syllable. I've never heard DNA, which is DNA, 3 claps if you remember from school. DNA. DNA. Anyway, and she can't speculate here. Apparently.
One more thing, Mr. Tucker.
Yes, sir.
I really don't want to go through the empty share tomorrow morning. Would you like to start at 9:15 tomorrow so you can factor in the traffic and all the other?
Well, Your Honor, whenever Your Honor is...
Well, I understand that. Like I said, I really don't want to have to deal with that issue or unpleasantries. So if I give you an extra 15 minutes, that ought to assure your punctuality.
Yes, sir. And like I said, I apologize. It's just,
I know. I understand.
She called us. Cheers. She called us.
Sure, I am here early, Your Honor.
Okay. So we'll say 9:15, and then whatever in terms of setting up this Zoom testimony. Let's kind of anticipate it. And we'll hear the motion for judgment of acquittal, and we'll go from there. So have a good evening.
Thank you, Your Honor.
9:15.
9:15. Eeyore has left the building. As he bails. Now we're gonna switch out. Okay, here's what I'm thinking. First of all, yes, the judge. Oh, I think Ivan's calling. He's been waiting very patiently. Just 1 second. Where is he? Come on, come back. Where's the call? Where'd it go? Ivan, did you hang up? I think he hung up. I don't see the call. The JOA. Let me back up. When I said he needs to say move for a directed verdict. A directed verdict and JOA are the same thing. A directed verdict is when the defense stands up at the end of the state's witness and says, Your Honor, I move for a directed verdict, meaning I would ask you, Your Honor, I know we've got a jury sitting here who's listened to all this evidence, but I would ask you to just look at everything the state's presented and realize that they have not proven their case. They have not proven every element that they need to prove to find me guilty. And you and your expertise and all your wisdom can see that and spare the jury the time of reaching the same conclusion, because legally they couldn't, because the state has not proven their case. That's what it is. JOA is the same thing. It means the exact same thing. A judgment of acquittal. So they're asking for the judge to step in and say, you're right. Right now in the case, we've seen all the evidence. You're not guilty. We have not proven that. We're going to acquit you. So that's going to happen in the morning. The thing that stood out to me was that the defense hang on a second. Why is my phone not working? It's trying to connect. Rebecca, I see you trying to connect, and it drops as soon as I try to connect. I'm not sure why. Just doing it again. This one's Ivan. Let's see if he can figure it out. Nope. Hang on, Ivan. Let me plug you in so we can hear you. Ivan, can you hear me? There you go.
So, yes. So first and foremost, before we get to this case, I don't know, I know true crimers might remember it. I don't know if you do, Recovery Addict. 5 years ago, on January 10th, Jamie Kloss from Barron County escaped her convictor, or her, I don't know what you call it, her kidnapper, after her parents were shot dead in her house by a single male, right?
Okay.
Yep. Rewind yourself. 5 years now.
It's news to me. I can't remember what I had for breakfast this morning, so you're going to have to explain it as you would to a child, Ivan.
Okay. So 5 years ago, Jamie Kloss was getting off a school bus, okay? She was 13 years old. It was 5 miles from my house at the time. Okay.
Okay.
And a sicko stalked her. Okay. And so this guy, about
Let's
3
skip
days
the graphic
later,
parts that we normally wouldn't cover. But
yeah, well,
continue.
basically, the man killed her parents with a single shotgun shot. He knocked on the door like a regular person and blew them away with a single shotgun shot, as you can imagine what that would do.
Right.
He later kidnapped her for 88 days, took her up north. Okay?
Okay.
He took her up north for 88 days, kept her under the bed with totes, with baggage,
Awful,
with whatever.
terrible situation.
Right? Yes. And then, you know, we had FBI here. We had thousands of FBI. We had thousands of people. Okay. There were helicopters. It was on CNN. It was everywhere. And then all of a sudden the FBI started leaving. Okay. And then it was getting very, very bleak, because once the FBI starts leaving, you start wondering like, oh man. But then 88 days later, she frees herself. Okay. She takes the moment, crawls from under the bed, and frees herself from the cabin up in Gordon, Wisconsin. Okay.
Runs for help.
Yeah, she frees herself. Yes. And so it is a huge day up here. It is all over local papers, you can imagine, because like I said, it was literally like her house was 5 miles from mine at the time. Like it was, I used to drive by it every day, because that was before we had the store. And so I was working at the creamery. And so like,
connect the dots for us here. This is 5 years ago, right?
Yes. And so like, it's just sort of like a reunion for it. You know what I mean? Like, it's just kind of like a feel good, like good things sometimes do happen in true crime, like that you never know. And so it's just like a never give up, sort of a scenario. But the key thing that Jamie Kloss never did, she was 13 at the time. She's never talked to the media. She goes to college now. She has a life now. She has you know what I mean? And so like, it's just, I don't know. I just wanted to like shout that out. Like, it doesn't really have anything to do with what we're doing right now. But like,
Ayden, you dragged us down this road. It's not relevant.
Well, it is relevant, because you know what? We are true crime, and we need feel good stories.
Talking about stuff that is not relevant.
Okay. So about the media.
Yes.
Are you tying that in that way as far as people in this case, people in the Maya case?
Of course.
We've got the media tie-in. Okay.
Of course. Because I just don't know which way this case goes because of it.
Tell me where you stand on this one. On this trial, the Treehouse murder trial. As far as the defendant, if we were to give a yes no, one word answer, guilty, not guilty for the defendant, as a juror, how would you vote?
Not proven. No, not beyond reasonable doubt. Like, you can't.
I think we're on the same page on that one.
Yeah, you can't. And boy, is that a rarity. Like, usually
we usually can find something to disagree on, I'm sure.
Yeah.
But
100%. Like, I don't think they've proven it. I don't think they've given it. I think the state is working for jury nullification, and that's dirty. And so I think I've yet to see anything substantial that plays into it. And so I think he was like, that's not to say I don't have my criticisms of Tucker. I think he was a fool to not take the time served, because heck, time served is time served. That means you're out. Like, okay,
yeah, but
he doesn't want to have this on his...
Tucker knew that the state was going to rest after bringing an expert on the stand to testify that say they had zero evidence linking him to the crime. If he knew that was coming, I mean, that might have been a very, it's a dangerous but a calculated decision that, I can't question now.
Yeah. Well, and I just saw somebody say, Ayden always thinks people are not guilty. Not true. That is not true. I thought Murdoch was guilty as sin. I thought that there are cases where it maybe they aren't guilty, but it looks guilty. Like, that is not the case. I think when you have evidence You cannot just say this guy hangs out with scumbags and then he's guilty. That's not evidence. Okay, that isn't evidence.
Yeah. Ivan, we're going to have to wrap it up. We've got a lot of the people who are trying to call as well. But thank you for the not relevant story and leading us down that path, keeping us hanging on every word and then letting us down at the end.
Bring it all in.
Thanks. And go Cowboys, right? No,
yeah,
sorry.
The Cowboys. Yeah, Cowboys. Go Cowboys in your long off season. Yeah.
Thanks, Ivan. Good talking to you, my friend. We'll see you. Bye.
Bye.
All right, I have to give him a hard time. Thank you. Let's see. We have for those that are asking, for those that missed this morning, the defendant, Mr. Tucker, Mr. Tucker's wife called in. Lauren called in and she spoke with us. We talked. She called twice because the phone call dropped. But she spoke with us and told us a little bit about the trial. I didn't reach out to her. She found us and reached out to me that way, and so I was willing to talk. And I made it very clear that I don't want to do anything in this trial that would in any way hinder or hamper or impede Mr. Tucker's ability to act in his own defense, because that is his right. He's chosen. I think it's the wrong decision, but that is his right to do it. And I would not want him to waste a moment of thought or time or effort thinking about what he would say to me in an answer when he could be spending that time preparing his defense. Okay, I have so much respect for that. I would not want to impede. His wife reached out to me. Lauren reached out. She was great on the phone. She cleared up some things that I was wrong about the relationship, and give us some backstory that really had me scratching my head. But she basically gave us the preface to this and said, hey, they've got nothing by way of evidence. They've got nothing. And now that the state has rested, this is what we've seen. We've seen, let's see, evidence-wise, we've got people who just were on the crime scene, who could say, this is the treehouse, this is where the body was, this is the street, this is everything. That's and that's not evidence implicating him.
Rebecca.
Hang on, just one second. Rebecca, hold on the phone for just a second, okay?
Okay, thanks.
All right. There was no evidence implicating him. Roger gets up on the stand. The closest he can say is that one of the two people that assaulted them in the treehouse was about his size, which is the same size as Travis. Okay, one of the two is about his size. The only person that has pointed the finger of blame that we heard testimony from in this trial was Travis. And Travis initially lied to the police, said it wasn't him, and then changed his story. He's got a sweetheart deal that basically he gets out free, time served. It's not free. He did almost 5 years if he cooperates. And he cooperated, and he sang like a bird. He sang the exact song the police told him to sing. They sang the song for him first. He learned it by heart, turned around and sang it. Now does that mean that they made it up? No. It could be true. The investigators could have got all of that right. And just in their expertness in the investigation, they could have gotten it all right. But it seems strange. And then you have his mannerisms on the trial, on the testifying. He remembers everything in detail, even dates. This is someone who's self-confessed a bit of a druggie, going on benders. Remembers dates, times, people, who was doing what, when, how it happened in detail. But then outside that, when it's on cross, no recollection. Seems fishy to me. To me, that seems fishy. He won't admit that he lied before, even though we can hear that he did change his story. Rebecca, sorry, I'm gonna take a deep breath and I'm gonna let you talk because I can hear you in the background. I'm gonna reset and we're gonna go on. Rebecca, what's on your mind today?
Can you hear me, or do I need to turn my radio down?
I can hear you just fine. That's great.
Okay. I just want to tell you how fantastic you are, and that I haven't called very much because Ayden is always hogging up the phone, okay? And I love you, Ayden, but and look, Scott, if Lauren calls, I'll hang up immediately, okay? So see how considerate I am, Ayden? And
oh, that's funny.
I think that he needs to stop while he's ahead, Tucker.
Yeah.
I don't know. So that's the question I have for you. I know he has witnesses and stuff that he wants to do, but the state has already rested, and that last witness they had, it was pretty clear that he's an innocent man. They can't prove anything without a doubt. And why do they do that? Why do they continue to go on and take the chance of another witness saying something else that's contradictory to something positive that's already been testified to?
I don't know how this got to trial. I honestly, this is so bizarre to me. If all they have is one witness who they know is involved, who took a deal, and yes, he knows exactly. He has details. He's able to provide details because he was involved, right? He's admitted to being involved, so that's why he knows the details. But he stands to benefit a ton. It's the difference between time served and life in prison. If he could just point the finger of blame at somebody else.
Right.
And you've got to weigh that and just say, man, do I believe this? Is this something am I ready to convict a guy to life in prison? Okay, which Mr. Tucker could face if he's convicted on these charges. Am I ready to convict a guy to life in prison based on this evidence? Because there was nothing else. Zero. I mean, I cannot stress. I realize I've tried to talk about this a couple times today, but with Zachariah Anderson. This chat is split. Most of the whole true crime community is split on this case. I was texting Solomon the other day. We're trying to get a catch up with him, just an update on what's happening with Zachariah, and that's going to happen here soon. But that
would be interesting to find out.
In that case, and Solomon knows, I sided with the jury, and I took a lot of heat. I continue to take a lot of heat from that. There's a lot of information out there that's caused me to reflect and think about this. But I believed that because of that one bit of DNA, I can't even say one bit of blood, okay? That was so small they couldn't even tell if it was blood or not. I'll just say one bit of DNA. It was where it shouldn't have been. And for me, it could not have been there unless something nefarious had happened. And it was a linchpin. It was a piece that means things fell into place, and I could not just get rid of that. The wrongful podcast. I'm listening to that now, Melanie. Solomon told me about it, and I had put it on my playlist and then never got to it. So I'm listening to it now. Hopefully, I'll catch all the episodes before we talk. But in this case, where we had basically no evidence, we're like, where's the evidence come in, right? Where's the part that links it to him? And then
where's all the stuff that would say you did it?
Yeah, and then we did have evidence come in. We did have the murder weapon come in. We did have masks come in. We had gloves come in. Oh, you're welcome. No, just kidding.
You know what? I'm so sorry. I'm in the drive-through at the pharmacy with Buttercup in the back seat, and every time I go through here, they give her doggy treats.
So you're on your third lap. Is that what you're saying?
Yeah.
Anyway,
I'm sorry.
No, you're great. The part that gets me is that to me DNA evidence holds a lot. It's scientific. It's something that can be proven. It's a number that I can measure, right? And so if there was no evidence at all, if they never recovered the knife, didn't have the mask, didn't have the gloves, then that's very, very different than when they find all the evidence and have no DNA on it. Now
that's right.
I know Solomon's gonna hound me on this, okay? Because there was very little DNA, and so I've got to think this through. Okay, I really have to think this through. But in this one, I cannot go to conviction on this. It seems like this is.
I can't either. I mean, I think he's innocent because of the DNA situation, and I also think he should quit while he's ahead. He should rest his case too, without bringing any of his witnesses in.
I think it would have been more effective for him to do a mic drop and to walk away, throw up his hands, do something. Let them object to his antics in the courtroom, but let it sink in. Let it hit the jury like a ton of bricks, and they're like, wow, and that's what they get to go home on and think on all night. No evidence.
Right.
No evidence.
Hopefully he'll bring it home when he does his closing argument, his closing statement.
Yeah.
Hopefully.
Rebecca, thanks for your call. Thanks for being patient. I've got another call coming in. It's not Ivan. Is it all right if I drop your call and take that one?
I love you, Scott.
Thanks.
Thank you.
Bye.
Call from.
Hello, this is Recovery Addict. Who am I speaking with?
AWOL. How you doing?
AWOL, I'm doing well. How about yourself? What's on your mind today?
Pretty good, thank you. This one case has me a little, I'm a little puzzled by all the evidence, right? Because I don't even know how to express this, but if you go to Blackstone's ratio, where it is better that 10 guilty persons escape than one innocent suffer.
Right.
I wasn't there. I don't know what happened. But if the evidence does not support factual things that we can all say, no, he did it. We saw it on video footage. He did it. Then I would go, yeah, guilty.
Yeah.
No problem. But it's a slippery slope that is dangerous. And I understand for all the true crime and all the addicts that this is entertaining, right? Not only as entertainment, but we also understand that we are all learning, especially from you, Lauren Lumber, and everybody else,
It's
right?
informative, but at the same time, we try to make it a fun environment at the same time.
Yes, and I love it. And you guys do an amazing, I told you 3 times already.
Thanks,
you do
Aaron.
an amazing job,
Thank
right? But we have to understand that there are as entertaining as it is, there are real life consequences at the end of the day with all this, right? So it's a slippery slope, because as entertaining as it is for us, if the shoe was on the other foot and I was in that courtroom, it's not entertaining.
It's not.
This is my life.
Yeah.
Right.
It's your entire
like,
future. Not just that. It's the past 7 years of your life. Okay. That's something you can't get back no matter what happens at the verdict. You might get the little bit of feel good of, see, I told you. But still, what have you done for the last 7 years? What's consumed your life? What has that done to relationships? What has that done to opportunities? It's real. It's very, very real.
And even if you get found not guilty, the stigma of society saying, I still think that you did it, even though the court system said that you're innocent, that doesn't go away. The stigma in society, you have to walk around as a guy that potentially got away with murder.
Yeah, that sticks with you. That you were charged, and you have to say, yeah, but I wasn't convicted every time. I was charged, but I wasn't convicted. It's like a little asterisk on the end.
And now you expect to go to your local grocery store or your church and expect the people to not look at you in a way of like, I still think you did it. That's a tough pill to swallow as well.
Yeah.
So it's tough with this one. I don't see enough evidence. I mean, for somebody that's per se for representing himself, he might not be as diligent. And the objections. There's so many leading.
I'm so glad we didn't do an objection counter, because we'd still be in the single digits. But it should be in the hundreds. It's just crazy. Hey, well, I've got another call coming in. I appreciate your thoughts. Thank you so much for calling. Thanks for the kind words as well.
Thank you so much.
Oh, you're welcome.
You're doing the best job, Scott. Thank you so much. I appreciate you.
Thank you.
Yes, sir.
Bye.
Bye.
All right, and right as that happened, the call dropped. It was the area code 615. If you want to give us a call back, I'll try to take your call. Love to hear your thoughts on this one. Let's see. Ivan, I love you, by the way. You're a good friend. Thanks for letting us make you the butt of the joke a little bit, but we love you. Let's see. What time did the wife call in? It was this morning, Sparkles. She called in this morning. The wife, she's mentioned she's not down there in Key West because she doesn't feel safe right now. That's the reason. Let's see. I don't know. This is a different call, but we'll take it.
Ricky Watson.
Mr. Watson, our favorite cowboy. How are you doing, my friend?
I'm doing well. How are you, sir?
Not bad. What are your thoughts today?
Well, I just had a question for you.
What's that?
When y'all or when you was on the phone with Miss Lauren this morning,
yeah,
I didn't get to finish her whole deal because my power got shut off.
Oh no!
So I was wondering if you can kind of catch me up just a tad bit on yonder.
Well, what I can tell you is Lauren is pretty smart. She's seen all the Discovery. for this case. So she's been everything they have, everything that made it to trial, everything that didn't make it to trial. There's a lot that didn't make it to trial. She's seen it all. And she's also seen all the antics and the behaviors of the judge in the court before the cameras got there, between the prosecution, everything. So she's got this whole background, and she has stories. She says she can talk for hours about this. But basically, it just came down to, we asked specifically, the question that was on everyone's mind is, why is he representing himself? Because I'm not going to out her on national television. She's done well. She's made a successful business for herself. He clearly would probably not qualify for a public defender financially, just for that reason. If his wife is financially in a good position, why would you want to represent yourself? And we asked that question, and she said, it's because it's a railroad, because he's being railroaded, because all this is happening behind the scenes and it's wrong. We said, you can represent yourself because that will get everyone's attention. And it did. As we're looking down the cases, we're like, whoa, pro se defendant? Let's check that one out. And that got us here. That got a lot of other people there. And now all the eyes are on the courtroom. And all the attention is on this. And it's much harder to have something that's wrong happen in the light as opposed to in a dark corner of the world. And so it was a strategic move by their part. She knows he's not a lawyer. He knows he's not a lawyer. But for him, this brings the eyes and the public's scrutiny onto the case, which they wanted. That's what they want. They want everyone, look at this. We want to show you all the evidence or the lack of evidence. They're not hiding from any of that. They want to bring more in. But the state does not have much to show. So crazy.
Well, yeah. I've kind of caught that part, especially when they had that knife box that was open.
Mm-hmm.
That should have been open inside that yonder courtroom.
Yeah, and the challenge with that one is that Rory, the other defendant, who's currently serving life without parole, the same weapons were used in his case, the same evidence. So it's been opened because of that. They can't undo. It's they did the other prosecution first and then him. So.
Oh, hey. Well, I'm sorry. I didn't want to be a horse's butt, but I just wanted to figure out what all she had to say this morning.
Yeah, I'd say go back and listen to it. It was really good.
Okay, I can do that.
Okay, thank you very much.
All right, I appreciate you.
Okay, thank you. All right, see you, Ricky. Bye. Okay, I'm going to have this person 615 call back, and I'm not going to take any of their calls until they call back. Just 1 second. So, let's see. We're waiting. Nobody else call except the person who's trying to call from the 615 area code. Let's see. I'll tell you, as far as Lauren and Mr. Tucker go, because of this strategy, this explains why they've been doing what they've been doing. They've been going on. They did an interview mid-trial with Court TV. They both appeared on a live interview with Court TV mid-trial. This is part of their strategy to get the public to see this case. So they haven't been quiet. They've been outspoken. That's why she hears about us and comes over here and calls and wants to talk. So that's part of the same strategy and for the same reason. Let's see. We're seeing. Hang on 1 second. There we go. The person who's trying to call in is delayed, so they think that I'm still on the phone with Ricky. So we'll see. Oh, here's the call. This is it. Here we go.
Call from Dana.
Hello, Dana. Thank you for your persistence from area code 615.
Hey, thank you so much. Thank you. Hey, I wanted to share something with you that just because I know that you guys are interested and you had so many questions, which I did too, about how this went to trial. And there is an article. There's an article it's called The Blue Paper, which I guess is like a local Key West paper.
Okay.
So I think you have to Google like Treehouse murder the Treehouse murders, the blue paper. But I didn't want to bore you. I don't want to take time away from other people. So I didn't know if you have it, if you wanted to. I don't think it's actually not very long, but I think that you would find it really interesting. So if you wanted to share it with everyone, if you had a chance to skim it, I didn't want to take time on the phone. But I think it has some interesting information about it. They talk about like there's 3 minutes missing from Johnson's interview that apparently no one knows what's happened to that, and they don't know if that's maybe that's at the time when they made some deals with him. But anyways, if you can pull it up, maybe while you're...
I'm looking at it now. I'm looking at the Key West and Florida Keys News. It looks like an online newspaper.
Thebluepaper.com. Mm-hmm. So if you go, it starts Treehouse murder, lead detective claims his boss coached witnesses and fabricated evidence.
Yeah, that's quite an opening. They're definitely not burying the lead on this one.
Yeah, no, they're not leaving you. You're not going to worry about. You're not like, I wonder what this is about. I wonder what their thoughts are. But they do give you. But so I don't know if it's biased or not. I don't know enough about it. But I think it has a lot of interesting information about how. I know you do. You don't like to put anything out that's not.
Vetted, yeah. I have to be careful. Even something that's vetted, a lot of times if I give something credence or give it a voice, I sort of get painted with the brush of the person who's saying it.
Totally understand that.
So I try to, even with Lauren this morning, I had to say, this is your opinion. This is how you feel. I don't know these facts. You're saying some things that are pretty alarming about a lot of people. But
yeah. And I don't know enough about, but I did think it was super interesting. And I read it before the case started, just because I like Google cases before I go in, and I read it and I was like, And then once the case, like now that we've got it and the state is rested, I'm like, okay, so everything that they said, and they talked about the $100 bill, which is in this article, but I don't know enough about, like with this case, I don't know. I feel like there's a lot of stuff that like didn't get in because, Tucker doesn't know how to argue stuff and get stuff into evidence. So I don't know if like some of the stuff with the $100 bill and the serial numbers and stuff like that I don't know if there was stuff that like he just didn't get in because he doesn't know how to argue stuff and get it in. But anyways, I just thought it was interesting, and I thought you would think it was interesting, and I just thought I would share it because I think it answers some questions about why they push. Because I think a lot of people, whenever you have a defendant that says he's, not guilty, I wasn't there, a lot of people are like, well, they didn't just draw your name out of a hat. Like they need to just, pick you. They didn't just like, so it's like, there's no way that this person's not involved somehow. And I think that a lot of us go into stuff thinking like, well, they didn't just find you out of nowhere. I think the article's interesting just because it kind of talks about like how his name came into play and yada yada. So
I'll look at that. Obviously, I can't share it on the air, but thank you for that. Okay. Interesting stuff.
Sorry to
appreciate it. No, you're good.
Thank you. I love the community you built. You are we are truly so lucky to have you.
Well, you are part of that community, and it wouldn't be the same without you. Thank you very much for calling.
All right,
call every time Ivan calls, okay? I'm just kidding.
No. I'm so sorry. No, Ivan was so interesting. Okay,
I love
thank
him.
you.
I really do. Thanks. Bye. All right. Here's Michelle says, I'm surprised you want a directed verdict. The jury is smart enough to understand what reasonable doubt is. They are, but they're also, I respect the jury's time enough to not waste it with something that never should have gone to trial. This is a move that it's not trying to get out of the jury deciding. It's out of respect to the jury's time. Say, this judge, there's no legal way the jury could convict. And we all can see it. It's so blatant. It's written plain on the paper here. No reasonable person under any view of the evidence could convict in this case. So ask for that. RA's shirt is not ripped. Yes, this is another one that if I flex right, you can see the vent on the back. I tell you, it gets hot in this room. I wear these shirts almost exclusively. I love them. Not ripped. Let's see, Kim R. I think you said a super chat earlier, Kim. If I missed that, I apologize. I put it on the screen, but then I didn't get a chance. Oh, there it is. I think there was another one before that as well. Kim, thank you very much for generous super chats. That helps the channel do what it does. So thank you very much. I appreciate that. Let's see. Florida taxpayers shouldn't have to be paying for this, says Melissa. It doesn't hurt to research all angles. I agree. I agree. But in a trial, and this is not to you, Laurie, this is back to a previous thought I was thinking about. In a trial like this, we now at this point, I guess technically we could do our poll now as far as guilt and innocence, because the defendant has no obligation or duty to prove his innocence in any way. At this point, if the state has not convinced us of his guilt, we should vote not guilty if we're on the jury. He has no duty. He doesn't have to present a shred of evidence. He doesn't have to stand up and say, well, here's what really happened, or here's why I was there, but why I wasn't involved, and this is how it went down. He doesn't have anything at all to prove. Let's see, who just came in. I just saw somebody pop in. I know we've got a couple friends who've rated us and jumped in chat. Thank you very much. We've got some great channels out there. Love it when other content creators share the love like that. And so if you see somebody in here, please welcome them. And then when you get a chance, go check out their channel as well. We've got some great people out there that provide great insight and analysis and interviews on a lot of these cases. And 13th jurors are here. We have no obligation to say he did or did not. You need to get sponsored by the shirts you wear. Cheryl, I go through so many of these shirts. I need like industrial strength ones, because I've torn them, I've cut them, I've got paint on them. I've worn them out, literally. I've worn them threadbare. Some of my favorite ones. I still have a couple that I should throw out, but they're good. All right, let's see. Anything else? Broken Baker and Eris is here representing. Thank you, Eris. Appreciate you guys. We raided you guys the other night right as you were ending. I said I feel bad about this. When we raid Broken Baker, he was covering the same case, the same trial, and he was about to raid me, but I finished first. And so we pop in right like during his exit video. His exit video, and he's like, well, I can't just, all these people who just popped in, I can't just like kick him out the door. And so he continues, and he was able to go over it again. And I felt so bad, because I'm like, he was done. He was like done. He could see that, he was about to ready to punch the clock and be done for the day. And then we jumped in. He's like, and we're going to stick around for a minute longer. Did a great job. All right. Let's see. I've said this before. Margaret says, I've said this before. Do I think he was involved? Yes. Do I think there were errors in the investigation? Yes. Has the state convinced me beyond a reasonable doubt? Nope. I would not convict. I don't know this part about involved. Sorry, I'm double clicking too fast. Do I think he was involved? I don't know. There has been so little testimony about his involvement that, and the person who did point the finger of blame is to me not credible. I realize that the members of the jury can disregard none, part, or all of any witness's testimony for whatever reason, based on what they feel when somebody's testifying or how credible they are. For me, it's not credible. And if I don't have that piece of evidence that I can say, yeah, I feel good, I can stand on that and say, yes, this is the getaway driver. Clearly, he's telling the truth. Then I've got nothing. I've got nothing other than that. All right, texts are going like crazy. Guys, tonight on this channel, we have a podcast. It's going to be with Weather Watch. Let me just double check and make sure Weather Watch didn't cancel. Checking. I think he's sending pictures of ski resorts or something. Let's see. Yes, I've got snow pictures from Weather Watch. Tonight at 8 o'clock, we're going to do a podcast. I've got some more work to do on that because I've told Weather Watch I would. So we're going to prep for that. If you want to be here, it's a little bit different from what happens during the day. We call it the Not Relevant podcast because we do go in directions that are very different from the court, the trials, and some of the heavy themes and weighty topics that we weigh in on every single day. So we'd love for you to be there. It's on this channel. The easiest way to find that is just to click the subscribe button and then ring the bell so that you get notified every time we go live. We'll go live tonight. It'll be at 8 p.m. It's different. It's very different. It's a lot of fun. It's very live like this is, and it's very interactive. So opportunities to pop in and chat and say something and interact with us are high. Occasionally, dad jokes surface. Dad jokes happen. But it is a little bit of a palate cleanser, Jinjo. So we'd love it if you join us and bring a friend. It's always more fun with friends. Let's see. Melissa says, I'm no longer getting any notifications when you go live. Have you tried turning it off and on again, Melissa? No, just kidding. Click the subscribe button. Again, make sure turn it off, turn it back on, and make sure your notifications on YouTube as well are turned on, because if your overall notifications are turned off, you won't get any notifications. But I'll bring Megan, says Krista. Awesome. Megan, you have a friend here. Nursey Dog Mom. Yep, that's how he was pointed out in the interrogation. My kids are asking something. Hang on. They're asking if I'm almost done. Yes, I'm almost done. What time will coverage start tomorrow? It's still going to be 9 o'clock, Tower Hill Girl, because tomorrow we have the judgment, the JOA, or the which Tucker still has to make the motion, right? The judge can't just assume that you made a motion. There's some formalities he has to do. So tomorrow morning he has to say, Your Honor, I move for a JOA, or Your Honor, I move for directed verdict, and then there's going to be argument back and forth. And granted, the judge has to weigh everything in the light most favorable to the state when it comes to evidence. So we'll see if that gets granted tomorrow or not. I think this one's going to be close. We might tear into the different elements that they have to prove, which should come up in the jury instructions as well. So
that's not him.
That's not him. Oh, that was not the right feed, but it was the right message. That's not him. Tomorrow is No Pants Friday. Yes, we've got a podcast tonight at 8:02 p.m. Thanks, Adam. 8 o'clock sharp. We're never late, right? Wow, what a day! What a day! Some of these memes I can't share, you guys. All right. Thank you all. AWOL Podcast. Appreciate talking to you. Imagine convicting someone just to find out 20 years later DNA proved their innocence. That would take a toll on my soul. All right. We are going to wrap it up here. I don't think there's anybody else we need to jump to tonight. I'll do a quick check just to see. But tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. We'll be live with the Not Relevant podcast tonight at 8 p.m. We've got a couple things going on. Danny on Direct is doing Missing Mother. Surviving the Survivors out. It's on right now. Storm Chaser Brandon's searching. Yes. Judge Alex Manning is live. She's the Not Relevant judge, but she doesn't let us use her stuff anymore. So anyway, I don't see anybody. We're not going to transition over to any of those tonight. We'll be back here tonight at 8 p.m. Thank you all. Please be nice to each other. Appreciate you guys being kind and nice to respectful to everyone in chat today. That makes it just amazing to be here. All right, I think I covered everything. First in chat tonight wins the internet for the whole night, and we'll have it till tomorrow morning. You guys be good to each other. We'll see you tomorrow. See you tonight, 8 p.m. Bye.